Good.
May I leave to file and move this application today? Tomorrow is the date fixed for dismantling my house with notice protection. Now, the order was passed on 28 January, 28. I was communicated on 30th. Now, there are 4 days vacation, and yesterday we didn't get the opportunity. Now, SDO and Pradhan usurped the role of a civil court and held that in an undemarcated land, I have erected construction, which could be termed as illegal construction. Now, there is no necessary for any civil court to decide whether my land is undemarcated or demarcated. They usurp the role of a civil court. Now, this is the urgency. Tomorrow is the date.
Any suit pending between the parties? Any civil suit is pending? Any civil suit is pending between the parties?
Nothing is pending. Only 145 CRPC was invoked. That is pending, madam.
Where is the order? Order.
But I don't have another copy since I just need to get a leave to file and move it subject to my lord's kind convenience.
You just indicate the order passed by the.
Kindly see on the right hand top, the order dated 28/1/2025 issued by Pradhan. Second, tomorrow is the date fixed for police deployment. Kindly grant me leave. I will file and place it before your order so that I can move it at 2 p.m. or any time subject to your lord's kind constraint.
It will not be possible at 2 p.m. I'll be tomorrow. I'll see. Leave the.
Lordship, may I
leave. We move tomorrow.
Tomorrow at 10 a.m. they would deploy.
Can't help it because second half I'll be taking up original side matters.
My lord, may I kindly mention one matter, my lord? This is urgent matter in the sense that my admitted payment is withheld for last 1 year. And from 2020 it is admitted. But this part is okay. My lord, this can wait. But the question is, my lord, that the business itself is going to be collapsed because of this huge amount of blockade of money. That's why, my lord, I was beseeching your lordship, let it be listed and the date may kindly be
fixed. It is appearing in the list.
No, it was appearing, but due to change of determination, my lord, it has gone down. So
you have given a notice.
I have given a notice.
What is it was appearing under the heading returnable motion?
Motion.
Now the motion.
But I am only beseeching your lordship, my lord. A date may kindly be, if possible, my lord.
No, let it be listed. Serially, I will go. Your matter will be listed under the heading motion. This is come under the motion or any order has been passed for it?
No,
nothing.
Not yet. Not even taken.
Who is for the state? आगे notice दिए थे देखो तो.
Lordship, may I be permitted, Lordship, to mention one matter? Lordship, I am for the petitioner and I am the legally recorded owner of my plot of land. However, some local goons are continuously harassing and they are constructing unauthorized structures in my plot of land. So, Lordship, if this matter could be kindly fixed. Lordship, it is running in the item number 322 of the daily list under the heading returnable motion 1. Yes.
You have given a notice?
Right, yes. Yes, Lordship. Notice is served via email, Lordship.
352.
322, Lordship.
Huh? No, list has 352 also.
Lordship, 322 under the heading returnable motion 1, Lordship, which is supposed to be taken.
अच्छा তাহলে ও লিস্টটা কবে পেলো কালকে লিস্ট দেখে বলছে affidavits have been filed in this case.
Sorry, Lordship.
Affidavits have been exchanged.
No, Lordship, not yet.
Not, or you are not sure?
Lordship, I'll have to take instructions on that.
Take the instructions, come back tomorrow. If the affidavits are ready, I place it under the heading hearing.
Lordship.
Huh?
Lordship. Thank you, Lord. Grateful, Lord.
May I be allowed to mention?
What is the stage?
My lord, one matter was dismissed for default in the month of August. It has been filed for it.
Application. Copy has been served. कोई application नहीं तो नहीं application for restoration देखो notice दिए कि नहीं State was not represented at the time of ठीक है list for application.
May I be allowed?
Wait. Yes.
May I be allowed to mention, my lord, for extension of interim order, expiring tomorrow. The interim order, my lord, I was
Interim order.
given notice, my lord, which was moved urgently before Justice Krishna Rao. At the time of, my lord, Mr. Amritulal Chatterjee appeared. Notice has been given to him, my lord. I annexed the notice as well as the order, my lord, kindly for.
February.
Or it's expiring month.
State. The call. Extension of interim order at a heading. Tomorrow.
Only motion, my lord.
No, only motion. All good. I'll come. Please.
Not with notice, I am.
Yes, sir.
My lord, with notice, I am.
Which was appearing for the other case. Since the change of determination of the matter has been infactual. I have talked to my other side to let it appear as for order. Any day, Lord, matter will take only 1 minute.
So give the other side. You have given a notice to the other side. देखो notice आ चुकी. Annex the notice.
Intimated.
No verbal intimation. Give in writing. I will place the mention tomorrow. Give in writing. New motion now. তোমরা সব হয়ে গেছে তোমরা কি দেখে কোথায় নিয়ে নাও নিউ মোশনটা নিয়ে নাও নিউ মোশনটা লিস্ট করো
New motion, যাতে
only new motion restoration कब आपका होगा
new motion. New motion.
new motion का all the new motions have been given.
Not with notice. Lay down in.
Now the urgency is to promote the tower without permission from the local authority and the panchayat. Building it without developing tracks and it's tilting. And I am being threatened by the gentleman. On a daily basis, kindly please come
It is not in the list.
No, it is 4 months we have filed this big petition. And I'm being threatened every day.
The list for the list. Give it. Let it come up in the list. Thereafter, we'll see.
Not with notice, I am mentioning one urgent motion. The matter initially heard
In the earlier bench, I'm directed to file a report. I could have the report has been filed. And there was a returnable date on 29, but on that day, bench was not sitting. It's very urgent.
A returnable motion in the hearing.
My lord, may I be
Who is on
permitted?
the other side? Notice দিয়েছে?
Yes, my lord, I have given notice.
State has been given notice.
State and as well as the private respondent. Next page. That notice.
What is this?
No, this is not.
Why should I accept this motion? Mr. Saha, give a
Notice.
at-
I have
at
given.
least- at least
This is
give
my
a-
notice. Next.
at least give a
No.
foolscap paper.
Oh.
Nothing on the back side. It should be a fresh paper. Come tomorrow and mention. Take the pen in mentioning tomorrow.
My lord, now.
Yes,
Very urgent
My lord,
matter.
here and now, I have corrected.
if you can, yes.
Yes.
Very urgent matter.
I mean, I can
I
check.
am appearing in person. It's my second read petition. Against the illegal and unauthorized construction started in 2011. My first petition was disposed by the Honorable High Court with direction to the Jilla Parishad to demolish the illegal construction. Instead of demolition the illegal construction, Jilla Parishad regularized it in the name of Nawaz. Again, I have come. And it is pending one hearing.
Notice.
Into order. And now out of this, change of the regulation. And it fixed a special for the hearing. Especially this hearing.
No, other side has appeared, affidavits filed.
For everything is ready.
Only hearing it.
Every file, I will reply in this hearing. Submit it.
There was a direction to file reply. There was a direction to file reply. No, hearing it listed out. You know,
My lord,
I have given the notice to the, while the matter was in
Mr.
the House of Honorable Justice.
So, who is for the state? Mr. Mondol is for the state. Mr. Mondol is appearing for the state.
Mandal is the Jilla Parishad and another private correspondent and Koda. And Honorable Justice directed me to I
Hearing it listed. Hearing will be hearing it listed.
May I be permitted to mention an application for restoration?
when it will
It will appear. Let them get the file and there will list it.
My lord,
Please, one by one, I will come to you also. Huh? Yes.
may I be permitted to mention an application for restoration?
Acha. Notice given?
Yes, my lord. Obviously.
May I have a lot of
Application.
permission to mention that matter, these are appearing as new motions. But due to change of determination, matter is not appearing. For
You know,
information.
motion.
I have for getting by the honorable I have person boundary wall is Panchayat area as the permission by the erstwhile owner to construct the boundary wall. Ultimately, the private respondent find a restriction was by directly private Pradhan to construct the right of constructing the represented they said no record is available in the Panchayat. My boundary wall is still legal. Filed initially was moved on 16. Directly status for the take insert with the particular payment and kind of 2 days.
But Indian returnable motion or
I be permitted to seek leave to file one urgent application, Lordship. Dispense with Rule 26 of the High Court Appellate Side Rules, Lordship. Urgency is that, Lordship, that the private respondent is construction of Paka construction using the plot of land which marked as a Bandh, Lordship, in the river bank of Damodar, Lordship. Now, the situation is, Lordship, knows very well, Lordship, that the LR Act is concerned, Lordship, Section D is that 4D is concerned, Lordship.
file it. Without leave,
File and
no,
when
no leave. File it in the
And
department listed accordingly.
Lordship, and another indulgence.
No.
Lordship, a restoration matter.
Restoration,
Restoration, the matter
notice
got
given.
No,
Notice,
Lordship,
give a notice and then
may I serve it in the course of the day, Your Lordship? Kindly allow the mention.
give a notice, come back tomorrow.
Oblige, Your Lordship.
Notice here, notice.
Notice.
It is in the stage of motion. Or the affidavit's directions were given. You man.
May I seek your kind indulgence to mention
Seeing a
one matter?
written instruction from your client for non-proceedings. Yes.
May I seek your kind indulgence to mention one matter? This is the civil suit in running from 1935 and appearing on behalf of the intervener. One GA application 109 of
Second half.
2015.
Original side.
No, I'm original side
Second
matter.
half.
And I'm a
Question? Where is the service? Your annex come tomorrow. Come tomorrow with the annex. Group 5. Which group? Panchayat. Check kar do. Panchayat. Group 5. Huh? No. It check na kore korun. 5. You have the copy of the petition? Petition you are carrying the brief. Bring the brief. Here, give a notice and then mention.
May I be permitted?
One matter, this is an MSME organization. Work as per the work order has been completed, but no payment has been done yet. The MSME organization is facing very difficulties.
It is motion or you have served the copies? It is returnable motion. What is it? No notice is there. What is the order pass?
I have to take
Give back the insurance slip. Give a notice to the other side. If they have appeared, wait. If they have appeared, give a notice to the other side and then mention.
Notice has been served, my lord.
Give that notice. Huh?
I am permitted to mention this was a matter which was been taken up in another court, and due to the change of determination, this matter has been out of list. It is a Group 5 motion. He is an ex-employee of the Panchayat, and
Group 5 state has appeared.
yes, your lordship, they have appeared, and we have even served a copy.
Okay. Shall we be hearing this affidavits they are filed?
Everything was done. Only they had to file a report, but till date the report has not been filed yet.
Keep hearing it.
May I be permitted to see that is the returnable motion, Lordship. In earlier occasion, the matter was taken up by the coordinate bench. Now, Lordship, it is the third round of writ application. Now, in this matter, Lordship, there is a direction upon the state to come with a report, Lordship, and the returnable date was 31st of January 2025. And the determination has been changed, Lordship. The matter was not appeared. It will be come under the heading of returnable motion.
What is given?
Lordship, that the state advocate that called me, Lordship, in yesterday. I have already informed them, Lordship.
Give a notice and mention.
By tomorrow, Lordship. That there is a 5 minutes morning.
Whenever you serve the notice and then come back. I don't know whether tomorrow or day after. Motion. Huh? Where were you? Where were you when the motion slips were taken? Neon? Motion. You are also not present. In the back side.
One matter, Your Lordship.
New motion now?
Lordship, new motion matter of 2023, Your Lordship. May I be allowed to mention one matter, Your Lordship? New motion matter 2023, Your Lordship. Now the urgent matter is listed, Your Lordship, as an item number, Your Lordship.
No upgradation.
Now, Your Lordship,
no
the urgency.
No upgradation.
Your Lordship,
Yes.
since Your Lordship, some urgency is there, Your Lordship.
Upgradation. Yes.
Lordship, pursuant to the matter I just mentioned, Lordship, I have taken instructions. The affidavit is of service is ready, Lordship. And yes, Lordship.
Notice দিয়েছে কিনা দেখুন দি হিয়ারিং এর লিস্টে দিন ওটা এইচ বলে লিখে রাখুন ওই স্লিপগুলোতে সব হিয়ারিং এর লিস্টে যাবে স্মিতা চ্যাটার্জি আমার পুরো হিয়ারিং এর লিস্টে It is in the list. It is in the list.
May I want
No, please.
restoration application.
Restoration application. No.
My lord, may I be permitted to be mentioned for urgent motion, my lord? My lord, the urgency is the
সার্ভিস করেনি নোটিস? এটা তো মোশনে আসছে, নিউ মোশন।
my lord.
জিজ্ঞেস করো। Dismissal, whether the state was there at the time of dismissal? At the stage of motion, it has been dismissed. ঠিক আছে, করে দাও। নাম্বারটা নিয়ে নাও।
My lord, may I be permitted to be mentioned, my lord, for application for urgent motion, my lord? My lord, the urgency is the my lord, the petitioner is a registered.
Sleep.
Be allowed to
মোশনে ডিস্ট্রিক্ট করে দাও।
include my matter on the monthly list. It was delisted from code number 15.
Who are you?
My lord, I am party in person.
In person?
Yes, my lord.
দেখো কি বলছো?
Actually, I filed the writ petition and on code number 15 it was pending, and due to determination it is been delisted from the list. So my lord, I want to put onto
The motion stage or affidavits?
yes, my lord, a new motion has been done at that time, but
Affidavits have been exchanged. The other side has
other
appeared.
side is other side has been noticed, and currently I've recently
The last order passed.
Last order passed was on bench of Honorable Judge Amrita Sinha to appear the state advocates for the state advocate to appear and
Check করে নিতে হবে।
in that stage.
You have annexed the order?
Not in this, my lord, but I have served a notice. Not served, actually, I have communicated over phone, and I have created the notice right now.
Serve the notice and then mention.
My lord, I have communicated.
Serve the notice upon the learned advocate who appeared for the state and then mention. চলো।
Item number 1.
Item number 1, Mr. Orindra Chattopadhyay is appearing for the state, but he is on his legs before courtroom number 8. I'm praying for not to them.
My lord,
At whose instance this is appearing under to be mentioned?
in this matter, my lord, I am appearing on behalf of the petitioner.
Why it is appearing under
My
to be
lord,
mentioned?
this is also my question. This is a new
It's also your question.
lordship. Matter initially heard by the my lord, by
It is
my lord
directed to,
justice
you are for the state.
My lord, my
Kapu.
senior, Mr. Orindra Chattopadhyay is for the
Anyway,
state.
you are representing the state.
My lord, no.
Where is
But
your
he is-
report?
When the matter was taken up, state respondent directed to file a report. That was served upon me, and I have also prepared exception to the said report. May I file the report in the exception? File হয়েছে তোমাদের?
You have filed a report.
No, report file we will file by the state respondents.
You have filed.
My lord, I am not for the state in this matter, but I have the report. My senior is representing the state, my lord. He is on his legs. I'm grateful, man.
Tomorrow.
Not today.
থাক, যেখানে ওই হেডিং এই আসুক to be mentioned.
On the same heading.
Same heading. Let it be there.
I'm grateful.
Item number 2.
I appear for the alleged
But you know, hearing.
You're not mentioning slip in white.
সাদা পাতা দিয়েছে। It is listed under hearing.
No, returnable motion. Returnable motion.
Returnable motion is.
I appear for the alleged contender. My lord's order dated 29th April 2024. At page 28, my lord will find the order. My lord will kindly recall, my lord, there were two sets of encroachers.
one under 62 Act, 1962, and Millard Highways Act 1964. Millard, it was extremely difficult for us because Millard, the entire administration was held up in the Ganga Sagar. But there has been substantial progress. Millard, may I place the report before Lordship? এটা দেবেন জজকে একটু। Kindly take paragraph 2, Millard, page 2, paragraph 2. You will find on 21st January 2025, serial number 11 to 38, except the club were removed. Lord, next, Millard, manually kindly come to paragraph 4, Millard. Under the 62 Act, Millard, the appellate authority has already passed an order. Passed a reason order, Millard. Millard, to my copy. Lord, directing demolition. Let's have paragraph 5, my lord, will kindly then come, Lord. Page 3. 7th, Lord, tomorrow is fixed for removal of the rest of the encroachment under the 62 Act. So, my lord, will kindly give us some time, Lord. We'll come with final compliance report.
2 weeks.
My lord. বলবো যে তোমার ইনভেস্টমেন্ট আছে অর্ডার একটা এক লাইনে করিয়ে দেবো দেখবে
আমার একটা রিপোর্ট
Mr. Nilotpal Chatterjee, learned advocate for alleged contemners, submits that substantial compliance has been made pursuant to the order passed by this court. He files a compliance report filed by contemner number 1, which is taken on record. 6. Some more time for compliance of the order in its entirety. Having considered the compliance report and the submissions made by the learned advocates for representing the applicant petitioner as well as the alleged contemner, state authorization granted a period of 2 weeks from date to conclude, comply the order passed by this court on 29th April 2024. সপ্তাহ পরে ডেট 21st February.
We remain grateful, my lord.
Grateful to your lordship.
Item number 3.
My lord, item number 3 on behalf of the petitioner, man. This is my affidavit of service.
এটা এটা ধরো এই তো ছিল
My lord, the allegation against the private respondent, my lord, this is my affidavit of service. The allegation against the private respondent purchased somehow the patta land in his name and recorded this land in his name and thereafter converted this land from Danga to Bastu Commercial. I have annexed all document with my writ petition and thereafter erected the multi-storied building, my lord, over that patta land. I given representation to all concerned, including the Panchayat Pradhan. My lord, page number 40. Page number 40, my lord. My lord, kindly see first, my lord, Annexure P1. This is the reply of RTI. Entire land in question is a patta.
Bola is the vendor.
My lord,
Balai Chandra Das is the vendor.
actual patta holder. He has been died at present. Thereafter, Balai Chandra Das handed over to someone, and that someone person sold this property to the private respondent.
Vera. Anand Vera.
Yes, my lord. There was a deed of exchange in between the Balai Chandra and Bera, Annada Shankar Bera. And Annada Shankar Bera sold out to the private respondent.
Who are you?
But I am the villagers.
You are the villager.
Yes, my lord.
Not affected.
I'm not affected.
Then?
But we are the villagers, my lord. But I have the right to file this writ petition, my lord. But there is no bar in.
How you are?
Draft of the earlier lead petitioner. Petitioner hearing. Director illegal and unlawful construction over the common land.
That has been disposed of.
Yes, yes.
That has been
I
disposed of. I have been mentioned in the writ petition, my lord. I
let
never
him file the
concealed this
affidavit.
matter.
One of the honorable bench of this honorable court passed an order against him by a heavy grudge. Subsequently, they filed this objection and page and writ petition matter. Not only that, my lord, I have a valid sanction plan which was passed by the competent authority, and I want to file affidavit in opposition to this petition.
File the affidavit. Who is appearing for the? You are for private
Private respondent number 7.
and for the state.
For submission of material facts matter.
State you have sub state.
Yes, ma'am.
Stranger who have doing part actually unauthorized construction.
But there is no any bar.
It's such application. By
There are so many cases, my lord.
material facts. Difficult to bottom record because of honesty or proper and effective application of the matter.
This repetition.
My lord, kindly see the page number 15, my lord, once.
Is filed for demolition of illegal pakka structure over the land comprised within LR plot number 1992 within bracket RS plot number 1937 gate number 51 Mouja Hatishar Mission Paskula district when sole learned advocate appearing for the petitioner submits that The Mr. Maiti is representing which response? Respond number?
7. Private respondent.
That the private respondent has purchased the land in question, which is a vested land, against which patta has been issued in favor of one Balai Chandra Das, who subsequently exchanged the patta with Sri Annoda Shankar Bera, and said Annoda Shankar Bera has transferred the land under patta to private respondent, who has constructed private respondent makes who has made construction over the land by illegally converting the Danga land to Bastu.
Bastu commercial, my lord.
Bastu commercial. He seeks for appropriate orders. Mr. Sulil Maiti, learned advocate, appearing for private respond number 7. It operates affidavit of service submits that the construction has been undertaken on a valid sanction plan. He seeks to file affidavit in opposition. None appears on behalf of the state despite service. পঞ্চায়েতে কি স্টেটের অ্যাপয়েন্টমেন্ট করে দেয় এখান থেকে? Is there any advocate representing the state? Mr. ওই তো আছে Mr. None appears on behalf of Mr. Lolit Mohan Mahata. None is appearing with the service has been affected upon the GP, office of the GP. You appear in this case? Mr. Lolit Mohan Mahata, learned additional government leader, is requested to appear in this matter. Let the appointment of Mr. Mahata be regularized by the concerned authority. Petitioner is directed to serve copy of this application along with annexures upon Mr. Mahata, learned advocate for state respondent. You file a report or an affidavit, whatever. Mr. State is directed to file a report in the form of affidavit. Exception thereto, if any be filed within a period of 3 weeks. Reply thereto, exception thereto, if any be filed within a period of 1 week. Affidavit in opposition, 3 weeks, 1 week. বুঝলেন? ওটা কোনো reply হয়ে যাবে 1 week. This matter after 4 weeks. Hearing a date.
Well, another same heading, kindly, my lord.
Not on the same heading. Go under the heading hearing.
Kindly fix the date at least.
For the 7th March.
Not kindly fix the date at least.
7th March. 7th March.
Item number 4. My lord, in this matter, Mr. Parthopratim Roy is appearing for the petitioner. He is on legs in courtroom number 5, my lord. I am praying only not today, my lord.
I am for the state, my lord.
One day accommodation, my lord, I am paying.
Okay, not today.
Grateful. Item number 5.
My lord, I'm for the petitioner. I'm praying for not this week. My senior couldn't attend to court due to his low fever, low pressure.
On the prayer of learned advocate for the petitioner, release this matter after 2 weeks.
Paper.
Item number 6.
Petitioner, my lord. Petitioner intends to not to proceed with the matter, my lord. This is my written instruction, my lord.
Mr. So-and-so learned advocate appearing for the petitioner submits that the petitioner does not intend to proceed further with the present writ petition. He files a written instruction which is taken on record. In view of the submissions made on behalf of the petitioner, the writ petition is dismissed as withdrawn. Entry model connection.
Item number 7.
I am appealing for the bill. So, petitioner is an enlisted contractor of the Korondigi 1 Gram Panchayat, that is respondent number 7 of the writ petition. The petitioner, Lord, felt aggrieved, challenged a NIT which was floated by that Gram Panchayat. In a particular clause, there is some restriction was made that only I can participate if Pradhan is certified my residential address. Felt aggrieved, I moved an application. That writ application was dismissed with observation that it is a harassing, etc. Against that, I preferred an appeal before the division bench. The appeal was there. In the meantime, when that writ petition was dismissed, Lord, they issue a show cause notice that is at page 27 for blacklisting me. Page 89, page 89. They think to dismiss me. Subsequent page 89, that is so cause. May I submit?
Yes.
It is to inform you that you filed and writ petition at Honorable Kolkata High Court against the Pradhan of the Korondigi 1 Gram Panchayat, challenging the NIT bearing consecutive memo number from so-and-so, dated so-and-so. But your petition has been rejected instantly by the Honorable Judge Aniruddha Rai and declared your petitioner as totally harassing, frivolous, vexatious, and without any merit. During the hearing of the court, many allegations were brought against the Pradhan as well as the block and district administration from the above incident. It is quite clear that you are trying to make the tender process on your own way by creating
unholy pressure on the Gram Panchayat and block administration. Not only that, you are also trying to hinder the development process of the Gram Panchayat mischievously, which is against the interest of the common people. After careful consideration of all these facts mentioned above, the Gram Panchayat General Body and Ortho o Porikalpana Upasamiti has taken an unanimous resolution on the basis of Section 69.4 of the Implementing Rules and Resolution of Part A IRRA of Republic Act number 9184 RA 9184. This is the act as referred. It is a act promulgated by Philippines government. They have taken on the basis of that resolution. I am asking a question to myself that whether this act applicable in India or not. Now I will place that act. Otherwise known as Government Procurement Reforms Act, to issue you a so-called notice for creating such pandemonium unrest in the Gram Panchayat. Hence, as per decision of the Gram Panchayat General Body and Ortho o Porikalpana Upasamiti, the undersigned direct you to show cause why legal action as per law mentioned earlier, such as suspension, blacklisting, will not be taken against you for such misdeed mentioned above. Your response must reach to this end within 5 working days from receiving of the notice. You are further informed that if you are failed to give reply within stipulated time, or your reply is considered as dissatisfactory by the Gram Panchayat, action as per law will be taken against you. Then, my lord, I give reply at next page, page number 91. My lord, second paragraph I am reading. I filed the writ petition being WPA number so and so, inter alia challenging the legality and validity of certain clauses incorporated in the terms and condition of the notice inviting tender dated 22/7/2024 and second call of 24/25 on the ground that the said clauses are in violation of Article 19 of the Constitution of India, in as much as cause prejudice to the healthy competition amongst the bidders. The said writ petition was dismissed with some remarks of the Honorable Single Bench of the Honorable High Court. I felt aggrieved against the said order dated 28/2024, preferred a mandamus appeal before the Honorable Division Bench of the Honorable High Court, which is still pending. Before higher forum, the appeal is continuation of the said proceeding. Therefore, you should not conclude on the basis of the order passed by the Honorable Single Bench. Next, the statement regarding during the hearing at the court, many allegations were brought against the Pradhan as well as the block and district administration from the above incidents. It is quite clear that you are trying to make the tender process on your own way by creating unholy pressure on the Gram Panchayat and block administration. I say it is not correct at all, because from the order you cannot establish about the aforesaid statement, and hence the said statement is redundant. I specifically deny that I am trying to hinder the development process of the Gram Panchayat mischievously, which is against the interest of the common people. In respect of your aforesaid allegation, I say, I, being a citizen of India, I have a right to approach the court of law when my fundamental right as guaranteed under provisions of the Constitution has been infringed. Apart from the above, the object of the tender is to execute work of the Panchayat in a healthy competition and with minimum expenses, with maintaining good standard of work. Hence, you are proceeded on wrong perception that I am trying to hinder the development of the Panchayat mischievously and against the interest of common people. It appears from the aforesaid so-called letter that you are directed to so cause by Gram Panchayat General Body or Ortho Porikalpana Upasamiti has taken a decision to show cause. You are in terms of the said decision issued the said so cause later, but no date of decision of the Gram Panchayat and general body or Ortho Porikalpana Committee has been mentioned, nor such any decision accompanied with the purported so cause letter dated 9/9/2024. Therefore, the purported so cause letter dated 9/9/2024 is suffering from the basic principles of law of natural justice. In view of the above facts and circumstances, I humbly request you to accept this reply as satisfactory against the purported so cause letter on 9/9/2024 and to drop the said so cause letter dated 9/9/2024. Then, my lord, impugned order at page number 94. Legal action against Nidhi Rani Enterprise. Subject. The undersigned inform you that so-called letter was issued to you from this end on 9/9/2024, bearing memo number 27 so for your various efforts to stigmatize the Gram Panchayat authority and to bring false fabricated allegations. And your reply to clarify your sanctity was received by the end within time period. After careful consideration of your reply, the Ortho Porikalpana Upasamiti has found that you could not clarify the allegations brought against you and your reply was dissatisfactory. Hence, the said committee has taken the unanimous decision on its general meeting held on 29/2024 on the basis of section 69.4 of implementing rules and resolution of part A IRRA of Republic Act 9184, otherwise known as Government Procurement Reforms Act, to declare your firm as Nidhi Enterprise as blacklisted for an year. The said committee also requested the undersigned to issue a notice accordingly for wide circulation. Hence, you are informed that your firm, namely Nidhi Enterprise, is hereby declared as blacklisted and you cannot participate in any procurement process for 1 year from the issuance of this letter. I have challenged this order. Now, my lord, I am placing some facts. Before this order was passed, I have challenged the impugned order passed by the single bench before the division bench. The division bench, my lord, initially passed an order annexed P8.
Page number?
Page 87, man.
Yes, page 87. That MAT application was directed to file an affidavit and it was appeared on 25/11/2024. On that day, it was stamp reporter report that no certified copy was filed. Therefore, learned Honorable Division Bench, my lord, opine that when there is no certified copy, there is no appeal in the eye of law, so appeal is dismissed. And then I obtained a certified copy by filing an application. Then I filed a fresh appeal, and that appeal was, my lord, disposed of on on 20th January 2024.
These are not the part of the distribution.
That is subsequent after filing.
But you have to amend or by way of supplementary affidavit. These are not the part of this distribution. How this can be agitated?
This is the fact which I am placing, my lord, whether that order, I have in reply, I have stated it is sub judice, therefore you should not take any action. Now, my lord, I am giving the copy of my lord.
By way of supplementary affidavit, I will not take this.
File a supplementary affidavit. Correct.
Let that, my lord. Okay, I will, my lord. I am extremely sorry, my lord. I shall put it on record by supplementary. Now, my lord, that the act which they have relied upon, that is the act of Well, I am extremely sorry. There is some marks on. So, this is act they have relied on. This act was, my lord, by the it enacted by the Senate of the House of the Representative of the Philippines in Congress Assembly. And they have relied upon that act and taking the decision. Under what authority of law they have got that power to adopt a foreign law? This is my question to myself. There is no whisper in that order that by such and such authority I adopted that law. Secondly, that they relied upon particularly clause
69.4.
69.4. Kindly see, my lord, 69.4. Page 21 of that act. Imposition and administrative penalties. Withdrawal of a bid or refusal to accept an award or enter into contract with the government without justifiable cause after he had been adjudged as having submitted the lowest calculated responsive bid or highest rated responsive bid. My case is quite different. They said, as I have filed the writ petition challenging that, that's why they have imposed the penalty like blacklisting. But under what authority? The clause 4 say, in case of withdrawal of a bid or refusal to accept an award or enter into contact with the government without justifiable cause, after he had been adjudged as having submitted the lowest calculated responsive bid or highest rated responsive bid. I am not coming on not a single clause of that act upon which they have relied on.
Yes.
Therefore, my respectful submission, this is totally malified action on the part of the respondent authority, as I have challenged a particular clause, and that clause has been, my lord, by division bench has been allowed my appeal and changed that you could not ask repeatedly in respect of different tender for residential certificate by a Pradhan. And in trial court, my lord, if your lordships considered the order of the trial court,
That has also not been annexed.
yes, it is not necessary because the basic foundation,
The court will not see, but I will not see what is the order of the trial
basic
court.
foundation
What is
of
the
the
finding?
backlisting is as I have challenged before the honorable court. Therefore, they have, my lord, the authority or the function of the panchayat has been interrupted. But that authority, when that I have challenged a particular provision of the constitution, that article 19, that every person have right to participate a bid, and in that particular clause restricted my right. Only I can participate if I produce the certificate from the Pradhan. And that clause has been modified. If your lordships asked to brought that division bench judgment, I shall make it supplementary.
As well as the judgment passed by
By
the
the
trial
trial
court in the earlier litigation.
I have got the instruction, my lord, this is incomplete because this appellate court order is not here in this.
That appellate court order was passed
When
on.
can you file the supplementary affidavit? I placed the
Yes.
giving you leave to file supplementary affidavit annexing the order of the single judge as well as the division bench's order. Mr. So and so learned advocate, you take this back. On that day you place advocate appearing for the petitioner seeks leave to file supplementary affidavit annexing the order of dismissal passed in. What is that order dated?
That is order dated, my lord.
Order of dismissal
28 November 2024. page 94.
No, not this order. The order passed by this single judge.
Single bench. That is order is 20th August 2024.
20th 20th August 2024 in writ petition WPA
20873 of 2024.
20873 of 2024, as well as
24.
the order dated 20th January 2025 passed in MAT 2208 of 2024. Leave granted. Let such supplementary affidavit be filed within a week. Within a week, list this matter after 1 week. 1 week for it under the same heading.
A particular date may mention other
14th February.
Deeply.
এটা দিয়ে দিন হ্যাঁ মোশনের হেডিং আছে আর অপরে দিয়ে দিন affidavit of service filed on behalf of the petitioner is taken on record. The service is complete with regard to the panchayat.
Yes, I have filed the supplement affidavit of service.
লিখে দিয়েছেন রিটার্ন মোশনে পরে তারপরে আসবো লিখে দেখেন রিটার্ন মোশন এখানে অ্যাকর্ডিংলি আচ্ছা কাউকে দেখি আপনার যে রিটার্ন মোশনে পরে আমি ফিরবো আপনার মোশনে আরেকটা মোশন লিখে দিন কি বলছে দেখি এরকম কত নম্বর আছে
Item number 8.
My lord, I'm for the petitioner, my lord. Allegation of my lord illegal unauthorized construction on the plot belongs to the petitioner, my lord.
Whether your lordship will continue with this.
Last item. If this is the last item of under motion, then I will go to returnable motion.
So my lord, the petitioner approached the civil court, my lord, and got injunction. My lord, page 25. Kindly have a look once, my lord. Page 25.
Affidavit.
Service has been completed, my lord, but my lord, out of 5 private respondents, one has been returned as door lock. But others
Complete
have
the
been
service and then
successful, my lord, including Pradhan, SDO, and my lord, other 4
no,
private
affected party. You are for Mr. Dhar is for private.
I am for the state respondent.
State.
Door lock since my lord long days. This is my lord. Respondent number 11.
8, 9, 10.
Against respondent number 11, you are seeking.
Yes, ma'am. It has been returned with the remark as door locked since 17th January.
How this respondent number 11 is involved in this present proceedings?
They are all are my lord responsible for this construction.
Then you serve and then come back. Complete the service. Affidavit of service filed on behalf of the petitioner is taken on record. It is found that the service upon the respondent number 11.
Respondent number 11.
11 has returned with postal endorsement door lock. Petitioner is directed to. As regards the others
Successfully served, my lord. My grievance is covered under section 23 and subsection 5 of the West Bengal.
Give a notice and then come back after 2. Petition is directed to serve appraise upon opposite party, no, respondent. Respond number 11 and file affidavit of service on the returnable date. List this matter on কবে দেবো রিটার্নের 11th February আজকে কত তারিখ within 1 week this can be completed
Yes, my lord.
through registered speed post with acknowledgement due করে দেবে ওই সার্ভিসের ওখানে 14th
14, my lord. Grateful, lordship.
হ্যাঁ এবারে যাও রিটার্নেবল
Item number 78.
By application, my lord. I for the petition, my lord.
News for the state.
And there on the other day, my lord, unwary queries. May kindly
nothing remains.
accept from the order book, the initial order on 20.
I have seen the initial order.
28th of April 2023.
Give a notice to the learned advocate for the state. There was a direction from the court for issuance of the check of the 50% amount.
Exactly.
Now they are to apprise the court whether this has been done or not. Nothing remains in the writ petition. If the check is issued, then you have nothing remains in it. Yes.
Otherwise,
Give a notice to Mr. Anwari Qureshi.
Yes. Unwary queries and Jainab Sahu.
Okay. None appears on behalf of the state.
78 returnable. And the fixed date, my lord.
By order dated 17th.
No, my lord. Initial order is 28th of April.
By order dated 17th December 2024. State was directed to take a firm and positive stand in respect of the claim of the petitioners. Since the state is not represented, learned advocate for the petitioner is directed to intimate the learned advocate for the state respondents of the next date of hearing. Is this matter on এক সপ্তাহ পরে রেখে দাও হিয়ারিং এর লিস্ট 14th
Friday.
Hearing is
It will retain the same position, my lord. I just give a notice and come back.
না রিটার্নেবল মোশনে রেখে দাও রিটার্নেবল মোশনে রেখে দাও ও তো রিপোর্ট টিপোর্ট দেয়নি এখনো রিটার্নেবল মোশনে
Retaining motion and the same position.
সেম পজিশনে রেখে দিই
I have not yet received the check. Otherwise, I would have.
On 14th, my lord, I have to come.
নামটা দিয়ে item number 79
Item number 79, my lord, I am for the respondent, my lord, private respondent number 8.
Lordship, I am for the petitioner.
15 January, supplementary affidavit.
My lord, I am for the petitioner. My senior engaged court number 5, my lord. Kindly note today.
My lord, the supplementary affidavit they have served upon me, but I want to file a my lord, opposition to this, my lord. Kindly grant me
Come
to-
tomorrow. Come tomorrow. এটা কালকে রাখ।
My lord, instead of tomorrow, can it be on next week, my lord?
Next week returnable করে।
Because my lord, or my lord may give me 2 weeks time to file objection.
Sir, let her senior come whether they have filed it or not. দেখো the supplementary affidavit
No,
file
they cannot file because the matter after direction of filing supplementary affidavit, today the matter is first time appearing. In the meantime, they have served me on 28th January the copy of the supplementary affidavit. Therefore, I am submitting that it must be ready with them. They can't file, my lord, because thereafter the matter is appearing today for the
আছে? না না supplementary affidavit এই না কালকে রাখো কালকে not today tomorrow come tomorrow
item number 80
মিস্টার মাহাতা চলে গেছে not today একটা নোট দিয়ে দেবেন ডেটটা নোট রাখবেন পেছনে
item number 81
81
Lordship, I opt for the private respondent, Lordship. In 81.
81, my lord, is my writ petition. The last order of the 22nd of January records that the state has filed one report. There was a last order 22nd of January. Order
file
Led by Mr. Divan.
Okay. Now, one report from the state has already been filed, but the state was supposed to file another report because it did not contain any annexure.
the order does not contain annexures and if prayed for a week time
Both the reports are served on us.
council please for
Without the annexures, Lordship, I have not been served with the annexures. Only the report has been served, Lordship.
what is the date of the report 30th July
My lord, the reports, one is 28th of, final report is 28th of January. So forward in the
no the report that is filed in court is 30th July that report was not having the annexure 6th August
5th August.
It was granted to the state to file the report dated 6th August 2024
one report which comes is on 3rd of July, sending here with a hearing report.
3rd July
Yes, Lord, you will see this, my copy. This is the 3rd July report, initial report, which is recorded in, I think, in the, this is Rao's order. Oh, it has gone as 30th July. This is the initial report. This is filed. This
3rd
was-
July 3rd
yes,
July yes
3rd July. This is the initial report. Now there is another one which is given by the state. I think only the
But that is, Lordship will see, that is 5th of August 2024.
yes, the other one is of
5th of August 2024.
The other one is a 5th August. Lordship must be having the report, but
Yes.
without that 5th August. But the difficulty is the 5th August report did not contain the annexures. So that is the recording of Justice Rao, though the dates are the typographical error in the dates.
No, that report is not filed. 6th August report is not here.
No, it's 5th August.
Huh?
5th August.
Or 6th August.
6th August. The covering letter is 6th August. Put a name. 6th August.
Memo number 61. Memo number 61.
629
Of
G10.
Which for the state?
That's 629 1629.
Pritam Chaudhary was recorded in the last order. Pritam Chaudhary was for the state. He will have to now circulate because I have a copy of the report. It has been served upon us by letter. Now it is
But
not served
after
upon
1 week, I am placing it under the returnable motion. You give a notice to the learned advocate for the state because that is required for the adjudication of the matter.
My lord.
Huh?
And it can be
my lord, a legible copy of the report may be served on us because we have got a illegible copy of the report.
Which one?
The 5th/6th August 20.
5th August 2024.
24. That is an illegible copy. So, my lord,
Oh, you have been served with a copy of 6th August
Yes,
report.
yes.
Oh, okay.
I have been.
Your is legible or illegible?
No, legible.
Your is legible.
I have a legible copy.
He doesn't have a legible copy.
No, my lord, only 2
By
days
order
were-
dated 22nd January 2025, the state filed a report dated 3rd July 2024. However, on the prayer of the learned advocate for the state, liberty was granted to file a report dated 6th August 2024 by disclosing all the documents within a period of 1 week from date. None appears on behalf of the state respondents. It is informed by the learned advocate for the petitioner as well as the private respondent that copy of the report dated 6th August 2024 has been served. Mr. So-and-so, learned advocate, Devashish Kundu, learned advocate, appearing for private respond number 9, submits that the copy of the report dated 6th August 2024 served upon the respond number 9 is not legible. State is directed, learned advocate for the state is directed to serve a legible copy of the report dated 6th August 2024 upon learned advocate for respond number 9.
Lordship, one intelligence
Learned
along with all the annexures and also the last report which was on 31st of July, Lordship.
Again, you go back to
Lordship, because I
everything.
don't find any of the reports.
Mr. Kundu says that the order report dated 6th is
That is also
not legible. So I have given a direction to serve a copy of 6th. Okay, learned petitioner, advocate for the petition is directed to intimate the next date of hearing to the learned advocate for the state respondent. State is directed to comply order dated 22nd January 2025. List this matter on date follow. Accept 14th.
I have some personal difficulty, Lordship. My mother is admitted in the hospital. I need at least 15 days time, Lordship.
On 14th, let them file the report. Mr. Kundu is there on behalf of the respond number 9. You are led by
I'm there for Lordships.
14th February.
14th.
Do me oblige, my lord.
Yes. Same heading.
Same. Online.
I'm grateful, Lordship.
Item number 82.
We can also serve. I don't know whether state will do it or not. Illegible copy, legible copy. I'll tell my on record to serve.
No,
them.
no, no. You don't do that. For convenience, let the state first serve because state is to file the report. So the responsibility upon the state to serve it. If they find any inconvenience, you cooperate. That is fine.
After 14th. But next week the discharge
Would be filed by the state. After that, they can.
If you have any
got the lordship, my mother is admitted only on that ground, lordship.
14 change कर दो
Standing in the way, then
14 change कर दो
17th এর week এ
নেক্সট উইকে দিয়ে দাও 14th এর পরের উইকটা কি আছে 17th হতে পারে 17th তো মানডে
হ্যাঁ
17th
17?
because the discharge formalities, that's the only.
21st দিয়ে দাও 21st
अब legibility of state
Item number 82.
Okay, next page.
I'm for the state, your lordship.
বন্ধ কর দো, বন্ধ কর দো, বন্ধ কর না।
Petitioner has been ordered for service to indeed. এটা not today করো ডেটটা দিয়ে দেব tomorrow
Item number 83.
Night please, your lordship. Milord, I appear on behalf of the Milord. I am being led by Mr. Chatterjee Milord. He is unwell, Milord. I am only praying for your lordship and fixes anytime next week.
Milord, I am appearing on behalf of the respondents in this matter on private respondents, Milord. I do not stand in the way.
Added respondents.
Added respondents. The thing is, yes,
you are added.
Yes, they are all they are with me. But no copy of, just a minute, no copy of the Milord application has been served upon us. Milord, there was an order. That order has not been complied with. I do not stand in the way when Mr. Chatterjee is not well. I should not make any comment thereon, but this is the 4th round of litigation, and all the time they have lost it. They want to run the Milord, a cowherd that we are stating. The state has submitted a report that a regional order has been passed and the writ should be dismissed. This is their submission. And my name is Mr. Mandal is appearing on behalf of the state.
We have ordered the application. And
Okay.
Stated.
Heart and heart.
This is the 4th round. Subsequent to one application after another application are being filed in order to grab the order. So in any day, the court may mold and the order may be passed. Illegally, they are running the heart. And the restraint order is also there by the
By which order the respondents have been added? These added respondents?
Last order. 28th of December 2024. Your lordship kindly see the order. And before that also, just a minute. This is 28th
I got
December
the last order.
Private
Private respondent was added. Post title was amended. Yes, Milord, that was served to the party.
Let the
That
court
was
go
ser-
through the
that was
order.
served
Let
to
the
the
court
party,
go
Milord.
through the order
My
first.
affidavit of service is not ready. On the next date, I will serve, Milord. I will file, Milord, my affidavit of service.
And they're
Say that
illegally
it has
running.
not been served?
No, Milord, I have served to the party.
No,
Served to
no,
the
not
party,
at
Milord.
all. There was no direction of
next date I
serving
will-
upon the
next
party.
date I
There was
will
a
file the
direction
affidavit of
to
service,
serve
Milord.
upon the respondents and the learned advocate. If this plea is taken that I have served upon the parties, that is not tenable.
Why?
You have to serve the respondents because respondents have entered appearance in the matter and the matter was hotly contested. If the matter was hotly contested, your lordship may give it.
Made by one other trade has not reached the hands of the one of the added response.
Nothing, and there was no such order.
Give a copy and
So give a copy. Where is the problem?
That can is still pending.
Who is
He has
he?
filed a can, Milord, that has not been allowed.
He's challenging my
Unless
locus
the can is
standi. The
allowed,
court
why
has
will I serve
decided.
him?
The court has held. Court
On
has
the
passed
last
the
order
order
on
that
28th of
that the
December,
copy may be
debate
served, and he's challenging
last
my
was
locus
added.
standi.
Not who has filed the can then? Unless the
Just
can
a
is
minute,
allowed,
just-
why will I
just a-
serve?
Court has passed the order. Why will you not comply with the court's order? Have you taken appeal? Have you gone into the? You have made any application for?
Is not aware of the facts.
No,
Milord.
no.
28th December, Milord,
You are not
Nivedita
aware of the
Das
fact
was
because you are
added.
appearing for the first time.
Nivedita Das was added.
You are for Nivedita Das.
He is
I am
appearing
appearing
for
on behalf of the added respondents. The lordship can't see the
Nivedita
order
Das.
dated.
You are also
Yes,
Okay.
single bench also.
Who has, I
Arre,
have not
who has,
received the
you have
can
no right to,
application,
you have no
Milord.
authority to
Unless
challenge
the
my local
can,
society.
the addition of party application is allowed, Milord. He is not a party to the proceeding.
Arre,
as
Baba,
of today.
Lordship, kindly see. Liberty is granted to the petitioner to implement the Nivedita Das Pandit.
I have added.
Respondent.
I have
This order
added-
has been varied.
Cost
This
title
order
is
has been
amended,
changed.
kindly, Milord, looks to
So this order has been varied or this order has been changed.
Cost title has been amended. Nivedita Das has been added. I have served a copy, Milord. Today, my lord, my affidavit of service is not ready. Next date, I will file, Milord. But, Milord, what my learned friend is saying, he has filed an application for addition of party. That can is still pending.
Forget about that
Unless the
addition of
can
party.
is
The
added,
court has allowed.
Can
The
is
court
allowed,
has-
Milord. How can
the court has
how can
allowed.
this addition of party, Milord? How can I serve, Milord?
I'm very astonished when my learned friend makes this type of submission. When the court has allowed by addition to be made a party, that whatever might be the fate of the can, forget about the can. The court has passed the order. Have you made any application for variation of this order? Not yet.
Then, but that is a technical issue which you are harping upon. If the prayer is allowed by the party, then he or she has been impleaded in the proceeding.
This is the law.
Now, once they
But,
implemented,
Milord, the can is still pending. I don't know who has filed the can.
You did not.
Can one is still pending.
You did not know.
Can
Nivedita Das
has filed that.
Pandit has filed.
He has been,
This
she has
is
been served.
technical. This is the way of misleading the court. The court has allowed. The court has allowed me to be added as a
There is
party.
no way I am misleading, Milord.
Of course.
Milord, my learned friend is misleading.
And
Then you
running the heart.
so the documents have been, I mean, the copy of the application has been served.
Yes, Milord. Next date, I will file my affidavit of service.
No, if you have any sort of endorsement that it has been served,
Milord, I will postal receipt. I will.
then why do you say so?
Milord, my affidavit of service.
Postal
Kindly, Milord, fixes any time next week, Milord.
Okay. A report in the form of affidavit filed by state respond number 5 is taken on record. Mr. So and so, learned advocate for the petitioner, seeks accommodation. Mr. Shambhunath Ray, learned advocate appearing for the added respondent Nivedita Das Pandit, submits that the copy of the writ petition and its annexures have not been served. Learned advocate for the petitioner informs that already the copy of writ petition along with its annexures has been served upon the party and he seeks to file affidavit of service. Let such affidavit of service be filed on the returnable date. Please this matter. Coming week affidavit in operation.
Convenience, Lord. They are illegally running the heart and earning the revenue.
14th.
14th. I much appreciate. 14th. Valentine's Day as chinta korchi, sir.
This is the only added respondent,
Yes.
private respondent, others is state.
Others is state. And the state has filed the report, Milord. And Milord,
After getting done,
Milord,
you-
I beg to appear, Milord, on behalf of the petitioner as well.
Mr. Chatterjee,
My lord.
they have been impleaded. Now your junior says that the copy has been sent to the party, but no affidavit of service has been filed.
Milord, if they were impleaded or not, that is a question, Milord, which I think is a little disputed. Because this is a problem, Milord, with respect to my license, where they had got nothing to do. Even before Justice Kapoor, Milord, when the matter was last heard, they were not, Milord, heard in as much as a
But
party.
the order records that liberty granted to the petitioner to implead Nivedita Pal as a party.
Right, absolutely, but they were not heard as such. That was because my learned senior friend came up with an application and saying that I have to be heard, I run a heart and things like that. They are not
That
parties
is above
interested.
the merit.
Yes,
What I
ma'am.
say is, since there is an order granting liberty to the petitioner to implead, you serve the copy. If it is
Very
not served, then give a copy to the other side. They have been
Absolutely.
added.
And there should not be any problem on that at all. My learned
Put a-
senior friend is there,
Before
but there is no
Birul
problem at
Babu.
all.
Mr. Aniruddha Chatterjee, learned senior advocate. Onar naam ta jagah? Appearing through virtual mode. After 1 week, you file the affidavit of service. Find out if not served, serve it.
Certainly.
And also dispose of the CAN application. If they are impleted, then nothing remains in CAN application.
Absolutely.
Okay. Thank you.
Grateful.
Same
Sorry,
idea.
Milord, when your
Yes.
lordship was in
Thank you.
Milord, Jalpaiguri bench, Milord, I have troubled your lordship. Yes and right.
We've
Okay.
traveled by lots for quite some time now.
Thank you, Mr. Chatterjee.
Grateful.
Item number 84.
You are for the petition.
I'm for the private.
এটাকে কালকেই রেখে দাও প্রীতম বাবু দেবনাথ বাবু not today tomorrow give a date
Be taken up next week, Monday.
আচ্ছা মানডেতে রাখো রিটার্নেবল মোশনে মানডে
মানডে বলতে 10
আমরা কোথায় যাবো ওটা
11 তাই তো
এটা ফিফথের লিস্ট তো 5 তারিখের হ্যাঁ ঠিক 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 আছে চলো
আইটেম নাম্বারটা
বুঝছো কত নম্বর আছে কি করবো তাহলে এত লোক তো ওয়েট করছে মান্থলি লিস্ট আছে মান্থলি লিস্টে তুমি রাখো মান্থলি লিস্টে একই সিরিয়াল থাকবে লিস্ট করে দিলেই পারতে
19957 57 হ্যাঁ আউট আসছে
ঠিকছে না এবার কি করা যাবে এটাকে এই লিস্টটাকে তো ওখানে দিয়ে দিলেই হয়ে যেত আজকের লিস্ট আমি এখানে স্টপ করে দেবো কেন আদারওয়াইজ হয়ে যাবে ওদেরকে রিলিজ করে দিই ডিফিকাল্টি হয়ে যাবে না কিন্তু অর্ডার পাস করতে পারবে না আইটেম নাম্বারটা দিতে পারবে না হ্যাঁ বলে দিই হুম আজকে ধর অন্য লিস্ট দেখা যাবে না মোশনে ফিরে গেলে অসুবিধা হবে অলরেডি রিজনেবল মানে না এক্সস্ট ধরেই তো পাচ্ছি কালকে কি করবে? ঢুকিয়ে দাও, কিছুটা না, রিটার্নেবল ওয়ানটা ঢুকিয়ে দাও। দিস উইল ফলো, রিটার্নেবল ওয়ানে তুমি লিস্ট করে দাও, আমি হিয়ারিং এ ওটাকে পুট করতে থাকছি। ঠিক আছে, দেখি বলুন। স্যার, এনিবডি ইজ ওয়েটিং ফর দি লিস্ট আন্ডার রিটার্নেবল ওয়ান? What is there is a problem because the list says that of 5th February, but it is not showing. So I cannot take up the list like this. So what I do is I take the entire return motion of one and put it in tomorrow's list. That will be convenient for you and as well as this court. No, that will, let me first settle down, huh? Prepare the list because today's list it shows that 5th February list will be taken up regarding returnable motion one. Now one of 5th February is not showing. So it is difficult for me to take up right now. So what I do is I cut the entire return motion one and put it in tomorrow's list. হ্যাঁ, এই অবধি স্টপ করো, ঠিক আছে? এখন মোশনে যেও না, কেউ নেই, দেখো কালকে ওটা পুরোটা দিয়ে দাও, রিটার্ন মোশন ওয়ান। তো ওদের কাছ থেকে প্রথমে জেনে নিলে না পুরো
May I have, may I have my lord leave to mention the suit, my lord? My lord, the parties have settled the suit, my lord. It's a suit for eviction, my lord. My lord, the terms of settlement have been signed by both the parties, my lord. May it appear as to be mentioned any day, my lord. I'm mentioning about notice. Monday.
With my lord, matter was mentioned this month, my lord. It is related to the Charushla estate, my lord. Two applications, my lord. We had pointed out to your lordship. The one is for the formation of the committee of management, and upon the formation, which is almost at the threshold, my lord, to be completed. My lord, upon the formation of the committee, the receiver will automatically stand eligible for necessity of a receiver any further. And the another is the removal of the receiver. But the two applicants we had pointed out, lordship wanted us to give a notice and to I'm mentioning about notice. Notice.
The other one, the previous one has been removed.
Yes, my lord, but Mr. Gupta was there. Mr. Gupta is
The one application has been filed by the previous receiver.
that was yes, man. That is there, man. He was removed long back and was confirmed by honorable division bench.
So
I cannot give any here. That was there. That was Mr. Pinaki Ghosh. In the crossfire of two receiver, the trust is the worst sufferer, my lord.
কবে আছে ওগুলো? ঠিক আছে।
Hello, may I comment to
Grateful,
mention this matter your lordship for extension of time to complete the satisfaction on commission. Served upon the district and the duration. If tomorrow, either tomorrow.
Last order.
When it is to expire, the time?
Set to expiring, it has already expired, your lordship, in the last week of January.
Where is the last order? Get the last order mentioned tomorrow.
Lordship, may I seek your kind indulgence to mention one matter? The matter, it was last mentioned on 19th of August 2024 for listing the matter, but till now the matter has not been appeared in the daily cause list and appearing on behalf of the intervener in this particular G application. Lordship. 19th of August 2024. It was last mentioned for appearing in the daily cause list, but till now it has not been appeared. The mentioning was allowed by your lordship on 19th of August. We have served the notice to the other side.
Let them check the records. If it is not listed, you mention after in the next week. Okay.
If it will not appear on the next week, then we have
come on the next week. You give the slip. Let him check. What is the matter? By
May be permitted to mention a suit upon notice, my lord. I am for the plaintiff, my lord. By an order dated 18th of November 2024, your lordship directed the plaintiff, my lord, the defendant to complete the inspection. They have completed the inspection of my documents. They have till that, my lord, there are other orders of, my lord, of the other bank coordinate banks as well. They have not disclosed any document. Kindly, my lord, list these as in a we mentioned, my lord, so that appropriate direction can be provided. I want to proceed with my suits. They are delaying it.
Yes.
By virtue of my lord's order dated 22nd of September, I was allowed to file written statement to the counterclaim filed by the defendant in the original suit. Now, my lord, what had happened, 90 days was granted to me from the date of issuance of the counterclaim from the department, since I did not have the copy of the. Now, I was under the impression that the 90 days would not include the vacations in the meantime. Now, my lord, immediately on 22nd of January, which was within time as per my assumptions, I intended to file it in the department. Department told us that the holidays will have to be counted within the 90 days. Now, my lord, I prayed for leave before the urgent determination with before Justice Rao. Justice Rao granted me leave to file the written statement subject to acceptance by your lordship. This is the endorsement given by. I'm only praying for my matter to appear as to be mentioned so that the WS may be accepted only, my lord. Since this bench was not sitting at that point, my lord, I had to.
To be mentioned.
I'm extremely grateful, my lord.
No.
Commercial bench. Witness in action, item number 1.
Your Lordship, I am for the defendant. Your Lordship.
Lordship, yesterday the matter was fixed on just on a simple point, whether the evidence should be by way of an affidavit or in examination in chief. The Lordship will kindly give us a direction. We'll file an affidavit in chief to give the evidence. Will give us 2 weeks' time to file the affidavit.
Mr. Anirban Kaur, learned advocate for the plaintiff, seeks accommodation to file affidavit. File examination in chief of the plaintiff's witness by way of affidavit. দেখুন বলুন, is this matter on? Twenty-sixth February.
At least, Your Lordship, before few days, if they serve us a copy of this affidavit on evidence, Your Lordship, so that we can be
Examination
prepared.
should be served upon the learned advocate for the defendant. Advance copy be given, much advance copy not to be given. If you don't say they've prepared, then they will serve. Thank you.
Emotion, item number 2.
Grateful, Your Lordship.
Item number 2, Senior Advocate Mr. Rudraman Bhattacharya was appearing, but due to some personal inconvenience, he had to leave court. Lordship, may I pray if the matter be taken up tomorrow or Tuesday, Lordship?
Tomorrow not.
Then in that case, if it can be taken up on Tuesday, Lordship.
First of all, this petition was filed without service, my lord. Upon me, I
It's
don't
been
know how it
served
was.
yesterday, Lordship.
It has
This
been
point
served,
was-
my lord, post appearance, my lord. Yesterday, the matter was appearing.
Lordship,
my
there
lord,
was an
let me
inadvertence.
complete. You
Okay,
must
sir.
have the
Okay, sir.
patience
Okay, sir.
of
Okay, sir.
allowing seniors to.
Okay, sir. Go ahead.
The matter appeared before your lordship yesterday, my lord. Till that time, my lord, this was not served. It was served in the afternoon. But I don't know how these matters are appearing before your lordship, my lord, when the notice of motion is not served, my lord. And it is not served to the advocate. If your lordship looks at the notice of motion, my lord, I am the recorded advocate on record, my lord. My name doesn't appear anywhere.
Lordship, the service has been effected.
January.
How? By a letter, my lord, at 2 o'clock tomorrow, my lord. And we have learned. We have at least something.
इन्हीं appear করছেন কার হয়ে opposite party এরা এরা opposite party এরই তো opposite party
Plaintiffs. And the plaintiff.
name
Yes, Kakrania. My
Abhaya
firm is the advocate on record, my lord.
Abhaya realtor
Abhaya realtors, my lord.
এটা এই ডিপার্টমেন্ট কি ডাকুন তো
Your lordship will see whether notice of motion was served before filing. It was not. But similar thing happened before the appeal court, my lord. My learned friend had paid for the appeal. This was dismissed, my lord. And my lord, that is after, my lord, that your lordship has, the petition has been filed. And my lord, it is a consent order, my lord. An application for recalling of a consent order, my lord, never heard of, my lord. I beseech your lordship to call for a report, my lord. But we are never able to find such petition, my lord.
I sincerely apologize, but what I have been informed by my clerk that while filing the document, the date has to be kept blank. So thereafter,
Call for
the
the
date
report.
has been put there. And Lordship was not sitting. There was an inadvertent mistake on my part, Lordship. The service was not complete. I served through email yesterday morning, and thereafter hard copy was served yesterday afternoon upon the advocate on record only.
But the matter appeared in in yesterday's list, my lord, and I was served in the afternoon, my lord.
Yes,
My lord,
Lordship, we
they
would
must
not.
know, my lord, the procedural rules. My
We
lord,
are,
that is,
we are not that.
I'm beseeching you, lordship, will call for the report, my lord. My lord, this should be taken care of.
Lordship, we know we wouldn't have proceeded ex parte. Lordship.
They cannot, my lord. This is an expert. It's a consent order. My lord. They cannot.
That inadvertence we are accepting.
Number is in proceeding. To pass method.
New chamber application, item number 3.
My lord, I appear on behalf of the applicant herein. So as per, this is a substitution application which has been filed by me. My lord, as per the last order, my lord had requested us to serve a copy on the defendants once again, which we tried to, but the advocate called Sanjay Bose refused to take service of the summons. Thereafter, we have served a copy on the defendants directly on the registered office.
You have served.
Yes. My lord, may come to page 11 of the affidavit of evidence. Sorry, of the affidavit of service.
Yes.
This is a substitution application which is being filed by the applicant herein, who is Namokar Vinimay Private Limited, for getting their name substituted in the place and stead of the plaintiff herein, that is Jardine Henderson Limited, and to conduct and proceed with the instant suit as the sole plaintiff. The reason being for such assignment is agreement for assignment for claim had been entered into between the plaintiff herein and the applicant, that is me, Namokar Vinimay Private Limited, in relation to this particular, all the right, title, and interest of the money which was supposed to be received under this instant suit. Accordingly, I'm praying for substitution of the applicant on behalf of the in the place and stead of the plaintiff.
My lord, I'm appearing on behalf of agreement. My lord, in page number 7 of this application, we humbly submit that we have no objection.
My lord, the amended plaint has also been annexed in this application, so that the
Wait.
at page
Jardine
number
Henderson, this has been assigned to which company?
to Namokar Vinay Private Limited, the applicant herein.
This you have stated.
Yes.
My lord,
Which?
page 9 of the agreement of the application.
Nowhere in the application you have stated that this company has been assigned. Name of the company to which Jardine Henderson Limited has been assigned.
I've referred it to as the applicant. In paragraph number 3, if you see that by reason of the execution of such a deed of assignment of claim, the applicant is now entitled to be substituted in the place and stead.
Who be substituted in whose place?
In the place of the plaintiff.
You need not state in the application. Awesome. Affidavit of service filed by the applicant is taken on record. This is an application for substitution of the applicant Namokar Vinimay Private Limited in place of plaintiff Jardine Henderson Limited. Mr. Swen Learned Advocate appearing for the applicant submits that the assignee submits that an agreement of claim has been entered between the plaintiff Jardine Henderson Limited as assigner and the applicant Namokar Vinimay Private Limited as assignee. And as per the agreement, the assignee has approached the assigner to acquire all right, title, and interest of the assigner in the claim for an agreed consideration. In view of the execution of agreement for assignment of claim, the plaintiff, Jardine Henderson Limited, be substituted by Namokar Vinimay Private Limited. He seeks for orders in terms of A to E of the master summons. Despite service, none appears on behalf of the defendant, Howrah Mills Company Limited. Considering the averments made in the application, submissions made on behalf of the applicant, and the agreement for assignment of claim. Acha, Mr. So-and-so learned advocate, much connected even, learned advocate, representing the present plaintiff, Jardine Henderson Limited, does not raise any objection. In view of submissions. Let there be order in terms of prayer A, B, D, E of the master summons. Department is directed to carry out the amendments within a period of 4 weeks from date of communication of this order. GA2 of 2024 stands disposed of.
Grateful, my lord.
দেখান তো এটাকে এখানে কোনো নোটিশ সার্ভিস করবে, নোটিশ তো সার্ভিসই হয়নি, আপনার টাইম কিছুই মেনশন করছে না, কি ব্যাপার? যেটা আছে, যে ডিফিকাল্টি আছে, আইদার ইউ টক টু দি ক্লায়েন্ট হু ইজ ফাইলিং অর ইউ টক টু দি রেজিস্ট্রার। এটা কি করবে? এরকম ব্ল্যাঙ্ক করে ছেড়ে দিয়ে আপনি দেবেন, এটা লিস্ট হয়ে যাবে, আদার সাইড এসে বলবে যে সার্ভিস হয়নি, না সেটা। হ্যাঁ, when you talk to the registrar, what is to be done? If it is not there, the other side is coming up to the court and says that the notice has not been served. না, কখনোই নয়। এসেই ডিফিকাল্টি কনফিউশন অ্যারাইজ করবে, আদার সাইড এসে বলবে যে নোটিস হ্যাজ নট বিন সার্ভড, why it has been accepted, why it has been listed. These things will continue. Why to get into all this? It is the duty of the applicant to serve and then come back. Now you have been served with the copy.
Yeah, afternoon, yesterday afternoon.
Now you have got the copy. Henceforth, আপনি নেবেন না, let them serve and then.
The only difficulty arose because Lordship was not sitting till 31st, so we were not sure with the dates, but immediately
Okay.
we have served.
What is this application? Now you will be filing any opposition to this?
Well, we have to, because a lot of allegations have been made. It's a consent order, my lord. Lordship has been pleased to pass a consent order.
Lordship, but in
Application under section 15, my lord, Lordship was pleased to transfer my suit, my lord, to commercial court. But they are seeking recalling of the order. They say The suit is not, it's not a commercial suit. And in fact, the prayer has been made for a stay of the suit also, my lord, by virtue of this order.
Okay.
So I would like to file my affidavit in opposition.
This is an application seeking for recall of order dated 3rd July 2024. Mr. So and so learned advocate appearing for the plaintiff seeks to file affidavit in opposition. Did such affidavit in opposition be filed within a period of 2 weeks? Reply thereto, if any, be filed within a week thereafter. List this matter after 3 weeks. Yeah.
Timber application adjourned, item number 4. Right to the lordship. My lord, continuing my submissions for the plaintiffs.
That evidence.
Commercial.
Yes.
I would not. I should kindly take up the master summons kindly once.
Yes.
Player A. That the witness does not but in support of that, they've already placed the documentation also. And one of the next part, and said exhibits tendered by him during his examination in chief, returned to the different numbers 2 and 3. Now, as my lord, I have submitted on the last occasion. Of course, my lord, party on whose behalf documents are produced has a right to that the admitted documents are returned. Apropos, my lord, of order 13, rule 9 of the court. Now, but that may I may the place order 13, rule 9.
CPC to me. Commercial courts.
Order 13, rule 9. Return of admitted documents. Any person, whether a party or not, observance of back in the document by ordered under they entitled to receive back the same A when the suit is one in which an appeal is not allowed when the suit has been disposed of. In the suit is one in which an appeal is allowed, and the court is satisfied that the time for preparing an appeal has elapsed, and that no fact has been prepared, or if an appeal has been prepared when the appeal has been disposed of. Provided that the document may be returned at any time earlier than that prescribed by the suit if the person applied therefore A delivers to the proper officer for being substituted for the original one. The case of a party just the certified copy, and 2, in the case of any other person, ordinary copy which has been examined, compared and certified in the Order 7 and undertakes to produce the original required. If my senior friend would have made a simplicity application as far as the second part of A is concerned, that I want these documents to return to me. I satisfy these criteria. I didn't have anything to say. My difficulty is the defendant has sought to link this up with the first part. That evidence should be expunged. Accordingly, this should be returned, and therefore, because so I can adduce evidence and whatever it is. This is where my objection to the second part is. And they have to also satisfy the order of rule. Now, so far so good, so to say. Now, prayer B, where I have really had on the last occasion really. The plaintiffs directed by the substance petition and denial with regard to the document towards the defendant's judges before document within such time as may be deemed written proper by this honorable court. Now, Lord, yes, friend, as by upon section 3, subsection 4 or 3 of the Commercial Courts Act 2015. But application. The provisions of this act shall apply to both procedures that were not complete at the time of transfer. Now, if I understand correctly, according to my understanding, this means that because admission denial has not been done because it was a district law. Now that this is transferred to this process of admission denial has to be done afresh. Now, my answer to this is one of twofold. First is that the suit has been transferred at the stage when the evidence on behalf of the plaintiff is complete, when the evidence on behalf of the defendants has been started, and midway of the evidence has been transferred. And what is significant and apropos my lord's point in the last occasion is what is meant by this phrase, those procedures that were not complete at the time of transfer. I was, my lord, I had tried to submit that this means that the suit would be continued from the stage it was already at. If a suit already pleadings were complete, and then, my lord, the suit has to be taken up from the framing of issues, so to say. If the suit is from the witness action, it will have to be continued from the stage of witness action. Now, in this suit, now, that is, my lord, the thing that that is the scheme of the code, and also, my lord, even post amendment by this or application to the commercial division. Pleadings, framing of issues, then, my lord, documents, discovery inspection, then, my lord, admission denial, then trial. So, my lord, my submission was and still is that this means that if in a suit the witness action has already commenced, there is no question of any further admission or denial. Because Lordship would also consider that admission denial, even under this new, even under the court in its application to the commercial division, does not happen once for the plaintiff, once for the defendant. Admission denial happens once when the parties have discovered the documents. So, it's not that when the plaintiff starts his evidence, the defendant would do the admission denial, and then when the defendant starts his evidence or evidence on behalf of the defendant is commenced, then at that stage the plaintiff would do his admission. No. So the stage of admission denial
is before evidence is commenced by the parties, which has long gone. The defendants in this case did not do admission and denial of my documents, while or rather not required to do admission and denial of documents.
Yes.
But today, I cannot be, my lord, compelled to do this. I cannot be compelled to do this. I would, my lord, take the risk of putting my case higher. Lordship would consider in a situation where my evidence is complete. Unlike this case, the defendant's evidence has not even started. Lordship would consider this situation. I would say, even in such a situation, admission denial is not called for, because the stage for that has crossed. Now, the question arises, my lord, that what is meant by this process? What is this is the very front, my lord, that once the suit is transferred, you are surely doing those statement of truth and everything you are doing. The answer to that, my lord, probably, my lord, subject to correction, is this. Statement of truth is really, my lord, on the procedural part. There is no, if I have to institute a suit on the commercial division, statement of truth and enter situation. But the court, under the scheme of the court, this is the entire scheme which has to be maintained. This is, my lord, if today Lordship kindly consider the situation. If I today do the admission denial, already where the evidence, my evidence has gone in, then, my lord, it may potentially operate to my prejudice. I am not called upon to do this, because according to me, this procedure, the term those procedures, does not contemplate a single event, does not contemplate a single stage. It contemplates procedures at various stages. One of these may be admission denial. Now, Lordship, in support of that, Lordship will kindly consider this judgment by the Honorable Division Bench of the Madras High Court. Lordship would kindly straight away turn to paragraph paragraph 49 at page 53. The page number is at the bottom left. Paragraph 49, page 53.
Yes.
Further, the words used in subsection 3 to section 15 of the CCA 2015 do not refer to a particular procedure but refers to multiple procedures. Hence, the legislature had used the words those procedures and not the procedure or this procedure singularly. Hence, the words in section 15.3 of the CCA 2015 cannot be construed to mean one singular event happening during the lifespan of a suit or application. The procedure is not the transfer of the suit. The procedure is at the stage where the suit was. Now, Lordship, for my benefit, before I turn to the next judgment, Lordship would kindly pick up the code as this applies to the commercial division suit once again. Lordship would kindly consider the amended order 11. Schedule to the
Yes.
address found. Now, Lordship would kindly just look at the heading. One is disclosure and discovery of documents. Then, my lord, discovery by interrogation.
Yes.
Pre-inspection. Our good findings, consider C1. Because it has been all parties have complete inspection of all documents disclosed within 30 days of the date of filing of the written statement or written statement to the counterclaim, whichever is less. The court may extend this time limit upon application and inspection, but not beyond 30 days. The time for inspection is crystallized 30 days from filing of written statement. Now, rule 4. Admission and denial of document. 1. Each party shall submit a statement of admissions or denials of all documents disclosed and of which inspection has been completed within 15 days of the completion of inspection. It is also crystallized. All documents, all parties, be done. After this comes, Lordship knows, Order 18 and all. Witness action.
Okay. Yes.
So, this, my lord, of course, might seem very obvious, but no change has been made to the fact that pleadings, inspection discovery, admission denial, then witness action, then arguments. That scheme has not been changed. So, my lord, if the procedure is already complete, or the stage of the procedure is already gone, if I may phrase it that way, the stage of the procedure of admission denial under Rule 4, Order 11 is already gone. That, my lord, cannot be revisited again. That's all I want to say. Now, Lordship would also consider, I must, my lord, I also point out last occasion, Order 15A, the newly Order 15A.
15A.
15A. In the
Commercial Courts Act.
Yes, this should be name.
15A, yes.
Case management hearing. Court shall hold the first case management hearing not later than 4 weeks from the date of filing of affidavit of admission or denial of documents by all the parties to the suit. Orders to be passed in a case management hearing in a case management hearing after hearing the parties, and once it finds that there are issues of fact and law which require to be tried, the court may pass an order. Then, my lord, 5. Case management hearings during a trial. The court may, if necessary, also hold case management hearings anytime during the trial to issue appropriate orders so as to ensure adherence by the parties to the date under Rule 2 and facilitate speedy dismissal of the suit. So, 2, in which additional denial has happened, there is 4 weeks from that date, not later than 4. But 5 indicates that it can happen anytime during the trial. The legislature was cognizant of the fact that there might arise situations where the case management hearing, for whatever be the reason, might not happen immediately after admission denial or in this. Because Lordship will also consider that for suits transferred, our High Court has held that for transferred suit, it's a different provision, it's a different. AIR 2021 Calcutta 169. You would kindly straight away turn to yes. Yes. So should kindly.
Yes.
Turn to paragraph 11, page 8. The page number is in very small font at the left hand. Paragraph 11, page 8. And understand. Subsection 3 of section 15 provides that when a suit was transferred to the commercial division of the commercial court, under subsection 1 or subsection 2 of section 15, provisions of the same act to apply to that were not complete at the time of transfer. Subsection 4 of section 15 provides the commercial court or of the commercial division before case management hearing in respect of such transfer suit or application in order to prescribe new timelines and issue such further directions as may be necessary for a speedy and efficacious disposal of the suit. The proviso to the state subsection states that the proviso to subclause 1 of order 5 of the CPC shall not apply to such transfer suit or application, and the court may in its discretion prescribe a new time period within which the written statement shall be filed. A conjoint reading of subsections 1, 2, 3, and 4, as also the proviso to subsection 4 of section Of course, this is in the context of. There might be an argument in the bar that each judgment is an authority for the proposition on the facts of justice. I understand. Hello. Once the stage has done, that cannot be. All of the cost of replacement may I not only point this out at the time. Surely, my lord, after completion of the evidence of the plaintiff, the defendant or defendants cannot be asked to put in the admission and denial of the documents produced on behalf of the plaintiff. And the stage of admission denial contemplated under the amended code in its application to the commercial matters only specifically provides admission denial has to be done once after inspection before witness action by both the parties of all the documents. This my lord.
But then see, section 15(3), what I was indicating that, since you say that there is no requirement under the process because that has been surpassed since the evidence has started. But what I indicated that there is no proviso clause in 15(3), indicating a stage that where the evidence has started, there is no requirement of any process with regard to admission and denial of documents. It says those procedures. But if you come to 15(4), it specifies that the court has the discretion to extend the timeline.
I bow down.
There is a proviso.
I bow down.
So how do you place your argument that those procedures does not include admission and denial?
I'm ready. First is my lord. I would say the twofold answer to this. I might be wrong. First is the way subsection 3 is framed. The last part, to those procedures that were not completed at the time of transfer, that itself is sufficient. That does not call for any proviso. The way 4 is framed, the first part of 4, for that a proviso is required. This is the first answer. That is enough. I do not require any proviso. I fall within that. Second, 4 proviso to 4 deals with filing a written statement. Now, Lordship knows under the amended code in its application to the commercial division suits, the time limit is mandatory. Now, as a mandatory provision, the legislature specifically, by abundant caution, makes it apparent, makes it clear, to look here, this will not apply. But as far as this procedural type, this inspection inspection, discovery inspection, then admission denial concerned, Lordship has, I have already placed those. It says, or within such time limit. So there's a discretion of court. The stage is fixed. Lordship, there are two different things. Lordship should kindly appreciate. One is the stage of the suit. One is the within which time the stage has to be completed. As far as written statement is concerned, the stage is fixed. The time is also fixed, mandatory under the code. It is stated in the proviso to 4.6. Look here, even though the time is fixed, I make it clear that this can be deviated from, so to say, as far as transfer suits are concerned. As far as the other stages are concerned, the stage is fixed, but the timelines are already subject to discretion of the court, as already the wordings of the section itself says. These are the twofold answers, my lord. I cannot think of anything else.
That's all.
That's all. As far as the notice of motion, the prayer C is concerned, I, of course, my lord, do not stand in the way. I do not stand in the way. They could have already done it, but anyway. Under Order 15A, I have already placed, Lordship can pass appropriate directions. That I do not stand in the way.
Let's start on the next day because my learned friend has today also given 2 more judgments. I want to finish at one go. I won't take much time of your lordship. I want to distinguish the judgments placed by my learned friend.
Okay.
And the applicability of those, the provisions as my learned friend has.
The Lordship's pleasure that we put in a short written note.
Short, which is sounding short, will be a long.
That's we do. That we do. But as a
if you intend to put in, then give madam the advance copy of that so that,
So that
she can also read out in
address
the
it,
next day.
on the next day.
Huh?
Lordship would then kindly grant me today, we are on Thursday. Kindly grant me till next Wednesday to put in the note. I will serve on next Wednesday.
Madam, next Wednesday, give an advance copy of that.
Next Wednesday, you'll not.
What you do is, do not put any other points which you have not asked. That will make her reply more long.
No, I would not. That I would, my lord. That.
Then prepare that and give it.
Next Wednesday.
Commercially, after next Wednesday, heard Mr. And so.
I was, my lord, beseeching that may I.
Since my learned friend is undertaking not to put in any new points, my lord, let him file the notes on that day itself, and I'll make my submission. And once if there's something else, my lord, then I can get the.
Okay. Mr. Swanso, learned advocate for the respondent, opposite party, no? Respondent, defendant. Mr. Swanso, learned advocate appearing for the applicant, seeks accommodation to place her replies. Please, this matter Wednesday.
I'm
Take an application.
For argument, item number 5.
For the defendant in this matter, my lord.
Intervene both the suits. Both the suits.
No, my lord. The defendant in the second suit.
What happened there are two suits. One suit has been filed by them. Bajbaj Jute Company Limited against FCI. The other suit is FCI against Bajbaj. But the matter was hard. But the Bajbaj Jute Company against FCI was being taken up. Although evidence, 2 suits have been mentioned. But the our suit, my lord, I said the problem. Our suit it has not been made ready, and only one suit was taken up for hearing.
My lord,
Yes.
the last occasion, my lord. My lord, we have, my lord, submitted that, my lord, while, my lord,
I am,
my lord, while making our, my lord, arguments, my lord, we will be relying on their, my lord, plaint, filing that, their suit.
Or if they,
Since to that
if
effect
the,
has been asked, my lord, in the
well, if,
deposition, my
if
lord.
the, well, this
My lord
rules
was of
permit,
the view
if the
that, my
rule
lord, to
permits at the
take
time of
judicial
their
notice
argument,
of that.
what is the rule permit করবে? Well, if the rule permits, my lord, then they can. Well, otherwise, my lord, the suits, the suit number 77 of 1981.
This is complete.
This is ready for hearing. This is ready for hearing. But I am just giving your lordship what is the suit about, and your lordship will understand.
But they was to, my lord, commence their argument.
I am commencing the argument with regard to their suit. Our suit, possibly the reason is, I am explaining to your lordship why the problem is. But this is a suit filed by them for recovery of go down pending as per according to them pending go down rent. But the FCI took two godowns. One is Boj godown and is Belvedere godown, which two are located at Sakrail, Howrah, for storing of our food grains. But along with the godowns, they have given us some office space according to them in the plain, and the railway siding, and one of the way bridge, or they have on a payment of specific rate. There are the was filed in the the tenancy was taken up in 1976. In 78, we have given them possession, returned them possession. But disputes arose with regard to the measurement, with regard to the repairing of the godown, and thereafter, they said that our pending, our rents are some rents are pending. But this is their suit for recovery of the rent. Well, our suit was that for the non repairing of the godown properly, the huge stocks of food grains were damaged. Well, at the godown, there are other godown of there, godown of jute mill, jutes were stored. That jutes caught fire, and by that caught fire, our stocks, food grains have been wasted. Well, FCI suffered loss, for which FCI filed a suit, our suit. That is the main two suits. Their suit is for recovery of their area rent. Our suit is for recovery of the loss of food grains and loss suffered by FCI with regard to the loss of fire, such and so. But the problem is, in this is a suit 44 years ago. None of the parties have any documents. They don't have any documents. They have typed copy of some documents. Well, we don't have any documents. That's why we couldn't make ready of our suit. All the documents have been, it is not available. Only 3 Xerox copies of the document I have produced before the court that has been put to the witness, it has been exhibited. Now I shall give it to lordship. But with regard to their suit, Lord, may I start with regard to argument of the main suit? But in the suit, we have filed written statement in their suit.
Their suit is 77.
Their suit is 77 of 1981. Well, old number, present number is otherwise.
578.
Yes. Our suit,
Okay.
our suit is
345.
345. That is our suit has not been made ready, we couldn't, because we didn't have any documents. All the witness, there is no witness because all persons were transferred, retired. Nobody knows. That's why you couldn't make the suit ready. But their suit, they have made the suit ready, and it has come for hearing, and we have appeared, we have defended, we have cross-examined. That suit is now being heard before your lordship for recovery of area rent, alleged area rent. Well, with regard to their suit, our claim is this: we have paid everything to them. Even, but there is a dispute with regard to the area of the godown. The godown rent was fixed as per the square feet basis. The dispute was regard to the area of the godown, and that's why we have paid 1 lakh something excess. Nothing is due to them. Now, my lord, this is the crux of the matter. Now, my lord, in this.
So far as the item number 5 is concerned, we can proceed with the argument. So we detach item number 6.
On the
No,
last
their
occasion,
claim is
Lord,
this. They are saying is this. They want
on
to.
the last occasion, my lord, we have submitted and we will be relying on their claim filed in their suit. Milord was of the view that Milord will take that suit along with this suit, and Milord will take
That's why
judicial
that suit
notice
has appeared.
of that their claim.
And your lordship
Because
has
we
been
will be
pleased to
relying
observe on the last occasion that
because
lordship will take
some
judicial
admission has
notice.
been made in their suit.
Judicial notice of that.
Okay.
Now, my lord, that is at the time of their argument, if they can, if the rules permits, they can. Now, my lord, I can now start.
So we
my
are
argument with
restricted
regard-
to 578 of 2020.
Yes. Now we are restricting to.
Yes. Kagos din. The possession has been delivered.
Possession has been delivered. Nothing. Possession has been delivered. Only with regard to their alleged claim of area rent, if at all.
Yes.
But in the suit filed by them, the huge bunch of judges' documents. There are so many documents. There are one brief is main judges' documents. There's additional judges' documents, but all are typed copy. None of the documents are exhibited. Only 8 documents have been exhibited by them. My lord, if your lordship kindly take up the judges' documents. আপনি যে আছে সেটা আছে দিন না in the judges people document the first exhibit was exhibit 8 is not in the judges people document, it is their board resolution to the witness to give evidence.
Page number?
Exhibit A. দেখাবেন জজ সাহেবকে এই এক্সিবিট গুলো একটু দিন না জজ সাহেবকে. There are only documents, 8 documents that has been exhibited in this suit, and we have given 4 documents placed before the witness that has been exhibited. Only those 11 and 4 12 documents are to be considered in this suit with regard to the claim of the claimant about their area, if at all. But their claim for area rent is 16 lakhs and odd total with regard to the entire 3-4 go down 16 lakhs. I am just giving the exact amount as mentioned in the plaint. It is of 16 lakhs 3,524.57. 16 lakhs 3,524.57. They are claiming that was due to them in since 1980. Our our counter statement, we have said that although we have not couldn't put any evidence, but we have said that we can get from them 1,18,070 paise. We are to recover from them, but we couldn't give any evidence to that because we don't have any document. 1,18,070.78 paise. 1,18,070 rupees and 78 paise. That is, FCI was to recover from them, but we couldn't prove that because there is no document with regard to us. But if you also kindly come to exhibit A is not irrelevant. The board resolution to the witness for giving evidence. Exhibit
Exhibits.
the
Exhibit 8.
Exhibit A. A. That is a board resolution to the witness of the plaintiff to give evidence. Exhibit A1 is the signature of the director. But I'm not on that. Exhibit B, but the relevant exhibit B, well, you'll also kindly come to PD1. Well, the judge's people documents. PD1 is the exhibit B. Well, have you lordship got that? PD1. But I'm also giving lordship the reference number of the questions by which these documents have been. The question number 22 to 36 is the question number 22 to 36 with regard to the exhibit B. এখন দিতে হবে না 5 একসঙ্গে গোছানো আছে তো
22 to 36.
22 to 36. These are the questions by which exhibit
Relevant questions to
B was-
exhibit B has been put to the witness.
It's a document regard to a offer letter by the party to the FCI about the watch go down. But exhibit B. But I'm not reading the exhibit B now.
Okay.
But exhibit C. Well, DD1. Well, DD1 is the documents, the mainly DD1. I think it is not paginated by them in the middle, well, after the end of their DD1, but DD1 starts.
Yes.
But the exhibit C is a document by which the Belvedere godown was offered to FCI for rent. But the exhibit C and exhibit 1 is the same. Well, I have produced the original Xerox copy of that letter. That letter I want to read because I don't want to read the type copy of that document. Exhibit 1. There is a document, exhibit 1. But exhibit 1, I will also got that. Say later dated 12th March 1976.
Yes.
But may I read that letter? By this letter, the terms and conditions of the rent have been offered to FCI. This letter is important, Malor. But I am reading this letter. The exhibit C and exhibit 1 is, well, I don't know whether it is typed correctly or not, but exhibit C is the original letter, Xerox copy of the original letter. Exhibit 1. Exhibit 1 is the, all documents are typed copy filed by. May I read this? This is, you know, so kindly mark the date. 12th March 1976 is the date, very important. And one of the middle portion about the godown's name, the godown space measuring about 2,60,000 square feet at Belvedere. But the question mark Belvedere and the square foot is very important. But there's so many godowns. You'll see people go to the plaint. I read the plaint at least 40 times and I forgot. But it has been written in such a way, but I couldn't. I have to understood it well. Well, now just kindly, I am reading now. Well, this is the Belvedere godown with regard to the document, and well, I am point 123. I am reading. The rent is 33 per 100 square foot. You shall have to deposit 1 month's rent as fixed deposit, adjustable in the last month of your tenancy. Besides this, you shall have to pay 1 month's advance rent at the time of our handing over the partition to you. But the column number 1 is the important. Column number 2, the deposit of 1 month's rent. Number
Yes.
3, my lord, I am reading. Sir, you shall have to pay us the rent for every month within the first week of the month for which it is to be paid. In order to enable you to pay the rent in the first week, we shall be sending you our bill within the third week of the preceding month. What is very important. My lord, you also kindly put the language of the 4 is well the crux of the entire case. The lessee will be, the lease will be for a period of 2 years, with an option for you to renew it for a further period of 1 year. Option is given to me with an option for you to renew for a period of 1 year on the same rent. You shall have to vacate the space at the expiry of the lease agreement. If, however, you wish to occupy the space for further period, you shall have to enter into fresh negotiation with us for the terms, conditions, for the terms and conditions. This is subject, of course, to our being in a position to rent out space to you. But the clause number 4, my lord, I am on the point, my lord, I am just giving you a lot of hints. The position was given to us on 17th March 1976. Witness, I shall come to the specific point in the witness. I have marked it. 17th March 1976. Now the 2 years expires on, my lord, on 17th or 17th March 1978. 2 years March. Now, my lord, the option for us to continue for was given to us for 1 other year. Now we have, you also kindly put the date. We have surrendered, we have given them back to the position of the godown on 31st March 1978. Position was given, my lord, 17th or 18th, my lord, I shall come on the 18th March 1976. The 2 years expires on 17th of March 1978. We have given them back possession on 31st of March 1978. '78.
So no option was renew was
According to us, we have not exercised any option. We have not given any letter to them option. But another thing I am submitting to your lordship, we have given them one letter.
expired on 31st March 1978.
78, we have given them back position. Now, we have we were there for excess period of 17 or 18 days. Now, this is, my lord, Belvedere Godown phase 1. You know, say this is Belvedere Godown. There are so many godowns, there are so many space. This is for Belvedere Godown phase 1, 18 November to 18 given position. Yeah. 18th March given position. We have surrendered them on 31st March 1978. 16 or 17 days we are in excess. There, written, they are there. Now, my lord,
yes.
With regard to this go down, there are disputes about, my lord, the question I shall come later on. I am giving you such hints. They have to repair the godowns to make it store worthy. In spite of several letters, my lord, although they couldn't produce, they has been exhibited, the letters are not there. They have not done so. My lord, we couldn't continue. We didn't issue any option letter to them, and we had to surrender. Now they are saying is this: as you have not surrendered given back the godown on 18th of March 1978, and you have access in position for 17 days, that will be construed as an option for another year, and you have to pay entire years up to 35, up to 18th March 1979. Entire year calculation they have made a claim and to us, and that claim is bunch of the claim 13 lakhs and all. That is the main crux of the matter. Well,
Yes.
now the question is now the main question here, whether by staying more more safe 17 days more, does it mean an option as contemplated in clause 4? Number one. Number two,
Yes.
can they claim for 1 year's rent from FCI for that? And does it violate the terms and conditions of the clause of the between the parties? That is that is claim is 13 lakhs and odd. That their main claim. That claim 13 lakhs and odd. No, my lord.
This position was handed over on 31st March 1978. There is a document.
Yes, my lord. That document they have the cross examination I put to them. There is a document myself, and we have given a letter to them beforehand that we shall surrender. It is 28th of something February.
One after the other. Take.
That
We
we
will
shall
update.
surrender you. We shall give you back position on 31st of. Now, my lord, another thing in my lord, may I go on the other clauses of that? That is my lord, main issue in this matter. Well, we shall give you one clause 5. We shall give you 1,000 square feet of office accommodation, rent for which would be 1 per square foot. The 5 is we shall give you 100 square feet of office accommodation, rent for which this will be 1 per square foot. This is similar other. This is not connected with Belvedere go down phase 1. There are so many portion of the claim. We shall allow the use of a weighbridge, the charge for which would be the same as per the rates and charge of KCCN and company from time to time. With regard to weighbridge, no document has been exhibited. With regard to office accommodation, no document has been exhibited by them. We shall allow you to use the railway siding. All maintenance, inspections, and operational cost, the railway siding will be at your account. We shall, however, keep the railway siding at a running condition. No document with regard to railway siding, neither from us, nor from them, nor any bill, nothing has been produced, not has been exhibited. We shall carry out the repair as pointed out in our letter of the, but that is very important, clause number 8.
In
We shall
clause
carry
number
out the repair
clause
as
number 5.
clause number 5.
This is separate from the rent.
This is
This
separate from rent.
1,000 square feet office accommodation, 1 rupee per square feet.
This is other
This is separate.
separate claim, not from 13 lakhs. Bed value, there are two. There is I'm giving you lots of hints. Belvedere go down phase 1, Belvedere go down phase 2, office accommodation, extra the railway siding, the railway way bridge. These are all separate. There only Belvedere go down phase 1 is I have just talking about. Now you'll also kindly come to clause 8. Shall carry out the repairs as pointed out in our letter of even number dated 3rd March 1976. But I don't have that letter that has been exhibited. We hope to complete the work within 45 days from the date of our receiving the security deposit payment and the advance rent payment from you. But with regard to repair, we have put cross examination to the witness, and our claim is this: you have not made the repair worthy. But in spite of my question, they couldn't put any document about repair, nothing about the panchayat certificate, how the what repair has been done, not about the repair, what cost have been incurred. But I put them, but no document have been produced before your lordship. Only the cost examination, the admission are only the points to be considered here, as per my understanding. The repair should be carried out during your tenancy. Tenancy continuing, repair will also continuing. At the expiry of the lease, you shall have to hand over possession to us in the repaired condition, in which we shall be giving to you, subject to, of course, the normal guarantor. Kindly confirm the above terms and also arrange to pay us the security deposit as well as the advance rent immediately. The rent will be start from 15th March 1976. Now, this is the exhibit C. Now, will also kindly come to exhibit D. Exhibit D is my lord, this with regard to the exhibit C, the question number 39 to 46. Question number 39 to 46 are with regard to exhibit C. On exhibit B is the Bajbaj go down. Exhibit C is the Belvedere go down. Now, my lord, exhibit D, I'm just coming here, let's say PD2. This is also typed copy, my lord. Typed copy. They have exhibited. They have also got that is PD2.
PD2, yes.
Question number 47 to 54.
Wait.
This is a letter dated 23rd March 1976. I don't have any possession of this letter, but it has been exhibited. Although I have not given any consent, but it has been recorded, but it has been exhibited. Although this is type copy.
This is in respect of which?
This is in respect of subject hiring a Belvedere jute mill go down.
No, this Belvedere 1 is C.
Belvedere 1 is C.
1.
And this is D is also Belvedere go down. But although I don't have any, I'm reading it. I have to come to the fact because it has been exhibited, I have to deal with it. But I'm just reading it. This letter is 23rd March 1976. FCI to them. No. Letter from one department to other of FCI copy given, but yes, copy given to them for information appears. This from FCI to FCI. This correction is office letter, but it is from district office, not the regional office, not the PD office. But in this correction, this office letter of event number dated 17/3/76 addressed to Mr. AK for the letter with a copy to you as per other. This is to improve that the total floor area of the portion in the fixed state. And C4, set number C2 and 8 has jointly measured by designing of the bureau office. Comes to 2,67,831. But that measurement, if you will also kindly come to exhibit C, it was stated exhibit C is exhibit 1, 2,60,000. Now, after measurement, it comes to 2,57,000. Exhibit C, the exhibit 1 is the same. Exhibit 1 is the exhibit C, same as exhibit C. Now, we'll also Belvedere go down. Their offer letter was 2,60,000. At the top, you'll also kindly find that. and the godown measurement comes to 2,57,831. Therefore, there is a difference with regard to the area. Now that tallies with my written statement, what we have said, that tallies with my written statement. I don't know what's there, but tallies with my written statement area. Now comes to after measurement. As agreed to, the rent for each month has to be paid in advance. The advance rent is submitted by the parties forwarded here with 85,800 as security was by later about which is subject to further adjustment after carrying out the joint measurement at the area. Since the floor area is only 257,831 square feet, the excess amount to be tuned of rupees 715.77 has to be recovered from the advance bill now submitted by the party. Balance amount of rupees 6,084.23 is last month's tenants. So you are authorized to pass the bill. That is what the crux of the matter. Or that is appearing that we have taken the go down. Although the exhibit, now this is one of the exhibit D. And I'm reading that because these are the documents in our hand, in which we have to consider whether anything is payable to them or not. Now, exhibit E, my lord, there are two. Exhibit E is my lord PD3 and PD5.
Exhibit E.
Exhibit E is PD3 and PD5. There are two documents. These are typed copy. No original is available. Document kindly see for the exhibit PD3 and PD5. These are appearing. These as it appears. This is a bill filed by them with regard to one is for Belvedere go down, and another is for Watch go down. And with regard to this, I have a submission. But my submission is this, but we don't have any document. Now, at the time of hearing, they have in 2023, something like this, their advocate has written a letter to me, to the FCA that kindly produce all the documents to us because we don't have any documents. It is all lost because this bill was forwarded to you and it's supposed to be in your office, notice to produce. Now, notice to could be produced. That's why this bill has been exhibited. Now, first, initially it was marked as Exhibit X for identification. Now, with regard to the notice given by them, this bill has been, we couldn't answer because we didn't got that any document. This has been exhibited. Now, one thing, I don't know whether it is relevant here to submit to your lordship or not, but I have gone through, but I don't have any, I didn't find any document, any act or rules or any provision to how many years a party can put in document which, according to them, is disposed of or we have paid rent, nothing to, because our suit is there, we don't have any document. Whether our suit will stand or fail, I don't mind. Now, with regard to that, their claim, if they give a notice to produce at that initial time, that could have meaning. Now, after 44 years, if you say that you produce, I am giving a notice to produce, you produce some documents. If I can't produce, now you can exhibit and you can make a claim. But I have a joint issue here. Now, I don't find any provision or law how many years an authority can retain a document. But after going through everything, but I have gone through a provision in Payment of Wages Act. Now, in Payment of Wages Act, I don't know whether it is relevant here or not, but because your lordship can take judicial notice of any, as per the section 56 and 57 of the Evidence Act, the Lordship can take judicial notice of any act, rules of the government as prevailing in India. Now, the Payment of Wages Act is a prevailing rule, but I am submitting to the Lordship section 13A2 of the Payment of Wages Act. Evidence Act, the section I'm referring, section 56 and 57, about the taking of judicial notice, of the which court can take judicial notice. I'm just giving I'm not mentioning that. Only Payment of Wages Act, I'm reading that portion. With regard to how many years I have a company's duty bound to keep its records.
Fiction?
It's not Evidence Act. But Evidence Act will also kindly come to 56 and 57. Seven, that's of which court must take judicial notice. The court shall take judicial notice of the following facts: all laws in force in territory of India, all public act parts. But I just on 57.1, I'm just saying before the Lordship, if Lordship can take judicial notice of any law in force in territory of India. I'm reading the Lordship, section 13A, subsection 2 of the Payment of Wages Act. I'm giving to Lordship the book. May I read that portion? But I don't know whether it is up to your Lordship whether this provision will be applicable here or not with regard to the preservation of records in which I am entitled to, I am supposed to, not entitled, supposed to. Every register and record requires to be maintained under this section shall for the purpose of this act, be preserved for a period of 3 years after the date of the last entry made therein. Well, a bill has been issued. I have paid that. Should I keep the bill? Government authority should I keep the bill for the entire thousands of years? Now, after 47 years or 43 years, they have given a notice to produce of those documents. But the rule says, well, although it is another act, rule says 3 years you have to maintain this document with regard to referring. Well, now their claim, they will have to produce their case. They are saying that they are entitled to claim arrears of rent. So it is their case. They will have to prove which documents they will have to, because I know suit has been filed at that time. Because if the notice was produced, served on us immediately after that, or a reasonable period, that can be a ground for that. But after 81 suit, now they have given a notice to produce in the year 2000. But I shall give you the exact date. But it is in the cross-examination. Notice to produce the document. Now, it is my issue now up to your Lordship whether your Lordship will decide it or not. I'm going carrying on, my Lord, thereafter. This is, my Lord, you'll also kindly see that section 13A, subsection of the Payment of Wages. But I have not found any other act in which the provisions are there. Only I have found these. So this I'm referring. I don't know whether the Lordship will accept this proposition or not, whether these are other. Now, my lord, next I am coming to exhibit E. My lord, exhibit E I have shown to your lordship. There are two documents, the two bills. Now, PD3, PD5, exhibit F. My exhibit E, my lord, question number 70, your lordship. Exhibit E, question number 70. Now, my lord, exhibit F, my lord,
Question number 70. 70.
70. Yes, my lord, 70. Now I'm coming to exhibit F. This is exhibit. This is PD6. But this is PD6. My lord, exhibit F 75, 78. Question number 75 to 78.
Yes.
This is another letter, interdepartmental letter exhibited by them, although it is not, it is marked, not even marked to them, as I understand here. It is not even marked to them. The exhibit PD6 exhibit it has been exhibited by them. It is typed letter, and whether it is not marked to them, when it is marked to them, it is addressed to Bojboj Jute Industries Limited as appears. But this has been exhibited, although the signed copy, typed copy. But I'm standing here with the check number such and such, for which such and such, for 1060 towards advance rate for 1 month from 18/3/1976 to 17/4/1976 for taking over total godown space of Petitions Belvedere godown phase 1. From 18/3/76 starting date is mentioned. Space 2,07,831 square feet. Against your bid dated such and such for such and such as what you later cited above. Please acknowledge receipt thereof in the future and to request you to please do towards name for the senior assistant manager posted Belvedere Safrai. Further, I am also to request you to please send the bills for the month of April. Month respected proper account. This is a letter executed by them. Our letter to them, they are typed copy, not colored. Now, will also kindly come to then exhibit G. Exhibit G is my the PD7. It's my question number 82 to 87. Got this document, these questions are also written by them, CI, as it appears. Also not signed, no original is available. We acknowledge receipt of the above letter, along with your check on the structures contained advance sale for from 18/3/76 to 74/76. Kindly mark the date of the Belvedere godown. The 18/3/76 is the date of starting point. 18/3/76. Belvedere godown phase 1, for which the disputed question about the option and extra 1 year's rent, whether they are entitled to or not, 13 lakhs is involved. The second paragraph, in this connection, we have to point out that the total square feet area for which the rent is to be paid is such and such, and this is subsequently measured after measurement discounts, and our bill for the same has been submitted according for rupees such and such. Out of this amount, we are only 650.37% the fund of excess. If you find that we have paid short, that this would start from the regard to how much is the refundable per cases that is there. But I don't know what is the actual thing, but the no document is available. But this is an exhibit G. Now, your lordship, I'm coming to exhibit H. Exhibit H will appear in as the plaint. You'll also kindly come to the plaint. In the plaint. This is the plaint. In the plaint, there is a chart. Chart, plaint page number 13. Plaint page number 13. 13. You can see there will be a page 2 here. Page plaint number 13.
Into 13.
Page number 13. Exhibit C is it a page B page 77 1981. Lordship got that. A type copy of the type copy later. 77. 77. Number. But this is, I don't know, it has not been marked. This is the document, it is exhibit. If I am wrong, my learned friend will rectify me. The exhibit H is one of that page. Exhibit H, but it is not, it is a child calculation. It has been marked as an exhibit. Whether it is allowable or not, your lordship will consider. And this is, this has been marked as an exhibit. Now, question number 132 to 136 is the
In which question this has been marked as exhibit H?
Question number 132 to 136.
Questionnaire.
But I am coming to the question. Now I am coming to the question.
No, it is not listed here. It happened to exhibit H to the name. Even a G that is the name. Right into the mark correctly. H.
Although it has not been mentioned, I have given.
What is the question number? Question number?
Question number 132 to 136. Well, I have raised objection. My objection was not taken up. It has not been recorded even in the exhibit. But my lord has been pleased to observe that. My lord has been pleased. But it is my turn. Let will submit.
No. Turn means whatever you will like, you will submit. That is not correct.
No. What my learned friend is trying to say that he has put in an objection and that
My lord has been pleased to observe that at the time of argument you will submit.
Taken a record for it.
At the time of argument you will submit. My lord has been pleased to observe. But I didn't raise my voice at that time. I couldn't.
Nothing is there in the.
Nothing is there. It has been exhibited. It has been exhibited. Exhibit H.
No, you say that you have raised objection whether
has not been recorded.
that is not correct.
It has not been recorded. It has been exhibited.
No. This is incorrect. What you say. There is no reflection in the.
at the time of exhibiting the documents, my learned friend will not make any objection. And now, my lord,
But I have.
come up.
But it has not been recorded.
It was an inadmissible document. I can understand. Is my learned friend's right?
It is inadmissible document. My lord, number one, number two is this, my lord. I cannot give any, but I have just submit what is there. Now, your lord, I cannot say anything more than that. More than that. Number, may I now come to the questions part? Questions part. I'm just reading out the facts now. This is exhibit H.
এই লিস্টে এন্ট্রি করতে হবে যে লিস্টটাতে এন্ট্রি করতে হবে কোনটা এটাই কি এইচ এই আপনাকে দেখাও তো মিস্টার ঘোষালকে is this the document which has been marked as exhibit A?
না এটা না
See with you. See with you.
You have the copy of the evidence.
Yes.
You just indicate from the questions number 130 on onwards, which is the document, because the marking is not appearing here, but in the evidence it is exhibit H.
Kindly see 131,
Back here, sir.
page 30, everything is written there. Question number 131, you also kindly see. The exhibit number is there, the page number is there, everything is there. 131, you also kindly see.
Annexure C at page 13 of the
Yes,
plain.
that is there.
It should be annexure D.
Oh, my lord,
What is this?
that now it should be annexure
Your
D.
lordship, if your lordship kindly sees below the next question.
Is rent against Bedway Jurmi?
But may I have a look at the date for once? Because in our brief, it has been referred as B, and over there it has been referred as D.
May I continue?
Let us first understand C and D.
I think but it is there C. They have undertaken the record C and page 13. Page is been also given there. Only C if it is that should have been mistake.
Oh.
An amended plaint, I have been served with a copy. That copy is there.
E, annexure E has been annexure E to our plaint, to our copies of it. So that there is a difference.
So what should be? It is C.
It should be D. Exhibit 8 should be annexure D.
D.
Well, I have an objection to that, but what is there is there. Now, the argument will continue. At the time of their argument, if they can produce that, it is D, it is D. But I can continue with the C as it
The
is.
difficulty with me is that I cannot mark it which one is H.
But the amended copy of the plate with
Something has to be entered into as H.
H.
So that's why I'm giving you the plate. You find out what it is.
I have given you also kindly see this is the
If
plate.
there is a wrong recording and the witness says that this is in respect of rent of Belvedere phase 2, the contents of the document. Now, if it is an agreement and there is a dispute whether it is a sale deed and agreement, witness says that this is the agreement dated such and such, we accept that.
I shall submit your lordship. See, but because the amount also
No, something has to be listed in the exhibited list. Which one is the exhibit?
This is the question.
That I have seen. It deals with rent.
Yes. So
This
rent
is rent.
is basically annexure D.
Well, I shall show to your lordship because in my amended copy of the plate which they have served at the time of raising questions, this is their marking, this is their exhibit, this is their pagination. It has been served upon me. Page 13, exhibit C.
Yes.
This is there.
It is there. So it is Milord as same as ours, Milord.
The judge's brief of document, I think it will be C.
I know the judge's brief of doesn't contain Milord that document. So it has been marked Milord from the plane.
Amended copy of the plate. But that's the dispute. This is the document which they have exhibited.
Oh, shit. At the time of your argument, at the time of your argument, you indicate.
That will unnecessary. They will be clear. As per my amended copy of the claim. Now, my lord, may I come to the question, the question part? Examination chief.
এখন থাক ওই সময় ধরে মার্ক করবো যেমন আর্গুমেন্ট yes
But should I continue or my lord, the next day I shall do that? But I shall enter into the examination part.
Which day?
In next Wednesday, I shall be at Guwahati. Lordship, with my consent.
My learned friend is on legs, my lord. He has my lord, the advantage of
Next-
choosing a date.
Next Wednesday, or any date, my lord.
Mr. Kamal Kumar Chattopadhyay. He seeks accommodation to place his further arguments.
वही कहते भूल गए आज.
Release this matter. Okay. 19th. 19th. Right.
Item number 7.
If I am appearing for the defendant, Lordship, I am submitting my affidavit of admission and denial, Your Lordship. Lordship, how Your Lordship had directed to complete the inspection, Your Lordship. That could not be completed because, Your Lordship, the office of the defendant has changed several times in a span of 15 years. Therefore, we required some time to trace the documents, Your Lordship.
Copy is being served today, my lord.
Lordship, I am seeking some more time to complete the inspection, discovery and inspection process, Your Lordship.
Then what remains to be inspected? Since you have filed your admission and denial, what is remaining then?
Lordship, they have not inspected our documents.
Inspection, my lord.
That
You
has
have
not
to
been.
make your inspection.
Yes, my lord,
Give
they
a
have not
notice.
yet. But
অঞ্জন বাবু তাদের অ্যাফিডেভিট অ্যাডমিশন ডিনার কোর্টে নেওয়া যাবে না ডিপার্টমেন্টে বলে দেবো ঠিক আছে নিয়ে নি তাহলে affidavit of admission and denial of documents filed by the defendant is taken on record. Ms. Vedika Sureka, learned advocate appearing for the defendant, informs the court that the plaintiff is required to inspect the documents of the defendants. Learned advocate on record for the plaintiff is directed to cause inspection of the defendant's document on or before the returnable date. When can it be done?
well, we can take inspection whenever they are supposed to give. Let them give a date when they will give it.
Within on or before returnable date, upon notice. Place this matter on 26th. Under the heading framing of issues.
Well, may we also file our issues, suggested issues on the next day? Can you-
Grateful, Your Honor.
Item number 8.
To the respondent, but here there are directions for affidavits to be filed. I must make one submission, my lord. My client is in default, my lord. We have not been able to prepare the affidavit yet, my lord. If I could only pray, my lord, for one more opportunity, my lord, to file my opposition, will kindly
Mr.
grant us only 2 weeks. my lord.
Ronak Mukhopadhyay, learned advocate for the degree holder, seeks extension of time to file affidavit in opposition in terms of order dated 18th December 2024. Let such affidavit in opposition be filed within
2 weeks.
What was the reply? Within a week?
If it
My lord, I'm
come in-
suffering, my lord. My bank
Within a
accounts
week?
are my lord attached, my lord.
Within a week? A reply thereto, if any, be filed within a week thereafter. Is this matter for 2 weeks?
Deep leverage.
For the 2 weeks.
Deep leverage.
Much obliged.
Happiness to the end.
Regular bench matter item number 1.
Lordship, I appear on behalf of the plaintiff in this matter. On the last occasion, your Lordship had granted me leave to file, reaffirm the affidavit of documents on behalf of the plaintiff and file it. My lord, it's ready. I have served the advance copy upon the advocate for the defendant. As your Lordship had directed, I had also served him notice intimating the date of the matter. He has not appeared, your Lordship. May I just file OD?
I appear for the defendant, my lord.
May I file the affidavit of documents?
Need to file affidavit. Inform the court that several notices of defendant. If such inspection has not been made, you are for the defendant.
I am defendant.
So why you have not caused inspection of the plaintiff's documents in spite of notice?
And the notice was served. Recorded advocate, my lord. What has happened, my lord, the defendant himself, reaching 90 years of age now. The place which is the subject matter of the suit property was being used as his doctor's chamber. Now, my lord, I have instructions. Agrees to the proposal. Perhaps my client does not want to continue with the property, my lord. And agrees. We can try and talk it out because, my lord, even the defendant is unable to.
My lord, I think my client, the plaintiff, might be agreeable, but I'll have to come back with instruction, your Lordship.
My lord, it's a short time to explore the avenue, my lord, because the defendant himself is unable to do something. One stage, I don't get instruction. I think we can settle the matter amicably.
This is the eviction suit.
I'm not opposing, your Lordship.
Eviction.
Eviction, your Lordship.
Affidavit of what is this?
Documents, your Lordship, of the plaintiff.
Affidavit of documents filed by the plaintiff is taken on record. You have given a copy?
Yes, my lord.
Copy served. Learned advocate for defendant submits that the matter can be settled by and between the parties. Learned advocate for the plaintiff submits that he has to take instruction from the plaintiff. Place this matter on. Copy the
Grateful, your Lordship.
Madam, protocol limit matter is appearing under the heading to be mentioned.
Matter number 2. I beg to appear for the plaintiff. I have no idea why this matter has come up.
Which one? The share matter?
Yes, my lord. So this might have come up on the instance of the learned register original side. Because the share certificates have already been handed over to the learned special officer for the report. We haven't received the copy of the minutes. my lord.
The order from page. Nothing. It's a report of
Special officer will sign on that.
No, 2nd January order to make, 2nd January last order. In first page, ওই ছিল নাকি? এটাও তো সেই কারেকশনই ছিল, কারেকশন করতে গিয়ে আবার একটা মিস্টেক হলো, মডিফাইড অ্যাপ্লিকেশন আর তো কিছু ছিল না। What was the order in 10 December order?
Lord, the special officer was appointed.
Now after he completes that,
Lord, he will be taking the custody of the shares. He will be dematerializing it before the appropriate, whoever is the appropriate authority. And he will be distributing amongst the, there was a report of the commissioner, partition commissioner, my Lord Justice Rajabaz Chaudhary, as his lordship then was. So there was a report. In terms of the report, he will be distributing. My Lord, what has happened? My Lord, the special officer has taken the custody of the share certificates in our presence, my Lord. So we haven't received a copy of the minutes. Though we have signed, my Lord, we haven't received the copy. My Lord, that copy may be directed to be provided to us once for our records.
So this is yet to be completed, no? Yet to be
It's
completed.
a long way, my Lord. 100 sittings will be required. My Lord, our keys are all secured. Special officer will be at his retiring age when we get the money. Long run, the special officer is only around 30, 35. He'll be at the retiring age when the matter will be resolved.
That is what you are up to.
No, my Lord, that is not what I am up to.
Then
My Lord, the company's 90%.
what will Mr. Talukdar say then?
What? Mr. Talukdar, my Lord, has seen, my Lord, there is this much of share certificates. My Lord, 90% of the companies are no more there.
Oh. Then you are also not sure that you are going to get the shares. You are also not sure.
Well, maybe few of them, maybe out of 90 shares of companies, will be getting 10 or 15. That may, turn us into a millionaire. Those share certificates are valuable, but 80% of the 80 or 90% we won't be getting. Let's see what happens. Mr. Talukdar is taking steps, my Lord. Mr. Talukdar may be appropriately armed, my Lord, to sign on our behalf, on behalf of 3 of the
Those shares
plaintiffs and
are
defendants.
could not be delivered to them. However, after taking consent on specimen and advocates of all parties, shares Mr. Mehra 20 January specimen. Nine.
The special officer also held one meeting, my Lord. One meeting has been done
With the registrar?
before the registrar's or minutes. And there's a, I
This
think
matter is
there's
appearing under the
one-
heading
one
to be
meeting is
mentioned.
one-
আচ্ছা প্রথমে করুন to be mentioned আছে inadvertent typographical error has crept into order dated 2nd January 2025 in the cause title mentioning the name of the plaintiff as Vishwanath Law Sri instead of Sri Vishwanath Law. Sri আছে নাকি? Sri নেই? Sri. Instead of Vishwanath Law. Therefore, said order is modified to the extent that the name of the plaintiff in the cause title should be read as Vishwanath Law instead of Vishwanath Law Sri. Vishwanath Law এর নামটা italics, Vishwanath Law Sri italics. ঠিক আছে? Next. The other portions of the order shall remain unaltered. Peruse the report of the learned registrar original site dated 30th January 2025. It appears from the report that the share certificates and investment instruments have been handed over to the learned special officer. It is submitted on behalf of the plaintiff that the conversion of the shares into electronic form will take some time. In view of the above, let the matter go out of list with liberty to mention.
But what I also pray, my lord, with consent of all the parties, my lord, the special officer may be armed with the powers to sign on behalf of the plaintiff as well as the defendant in respect of any communications or any signatures required.
Why?
The three of us will be going and signing, my lord. One will come, one will not.
Take the pain in doing that. Don't keep everything with the
No.
special officer.
Special officer is trying his level best.
No, you say that he will retire.
Till the time we get the money, my lord, the companies are not there.
Expedite the process. How it will be done, find out.
One is in Bombay, one is in Chennai. We are trying, my lord.
Hmm.
Section.
Witness কি আছে নাকি?
Item number 3.
And then I'm for the defendant of 3, man.
Yes, in the box, man.
He has come.
Here, madam, I had to leave, madam, because there's a doctor appointment. Just 2 minutes back, he has left, madam.
Tomorrow.
Well, I have some difficulty tomorrow, my lord. Kindly fix it in the next week. Any day, my lord. Tomorrow I have some difficulty.
Tomorrow, 2 p.m. 2 p.m. tomorrow.
I have some.
With the consent of the parties, list this matter on twentieth. Thursday.
After your lordship takes up it.
Thursday, 2 p.m.
Grateful, man.
Item number 4.
I am for the plaintiff. I have taken out an application for amendment of the plan in view of death of one of the defendants and for consequent addition of party of his legal age. I don't think 1B they should not allow object. By consent it can be allowed. At least the amendment part.
They have filed in opposition.
I have not filed, my lord, any opposition because it's been appearing for the first time before your lordship. My lord, your lordship kindly takes, my lord, their annexure.
Tomorrow we'll take it up. Tomorrow.
Very good. Very good.
কালকে নেই কালকে इसको रखिए একটু আসুন